cause Mickey talks the truth.
Okay. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
We love you, Mickey.
Y'all already know all information contained on this live is for entertainment, heavy on the mother effing entertainment, educational purposes only. All information used on this live is per the Fair Use Act, and any conclusion that you draw is on you and your mama, not nobody on this channel, this panel, or in this chat. And another disclaimer for those who have not read the description to my channel, I am not a lawyer. Nothing I say should be used as legal advice because it's not legal advice, okay? If you do need legal advice, however, you can go talk to an actual licensed lawyer or attorney of your choosing, all right? And like the disclaimer says in the video, that you can actually see the consequences of anything that you try to run with from the channel is definitely on you, all right? So with that being said, hey, just sit back, enjoy my opinion based off my free thoughts of what I'm listening to, and y'all let me know what y'all think in the chat. Let's get started.
You can't handle the truth.
Make sure you like, comment, share, subscribe, tell a friend to pull up on your girl Mickey Truth. We is live with it. Good morning, Truth Team. Y'all, when I say this morning was definitely hard, okay? This is day 3 of Tennessee versus Hernandez Govan. And when I say we have been on live 9 hours on Monday, 9 hours on Tuesday, probably 9 hours today, it's starting to catch up with me, okay? I ain't a young Thundercat like I used to be. Good morning, Big D, Ernest, King Newski. But we are here. Y'all know we from start to finish. Y'all know I do work, okay? So I had to start my live a little earlier so that when I do my morning meeting with my client, I'm able to still already have this in place. Where's my notebook? We had a lot of, first half of yesterday was smooth. The second half, I think my chat hadn't just lost their mind. I lost my mind. I stopped even paying attention, okay? And then we had to run it back, okay? But shout out to the Truth Team because they was like, yo, Mickey, did you hear that? And I'm like, what I heard? I was on the phone running my mouth. So we definitely had to play it back, and it was some good pieces of information that was laid out. And I will give it to the state. They did do their job, okay? However, it was pieces, though, that was like, kind of shaky on the storyline, okay? And if you were with me last night, or if you have watched the video clip of the breakdown of, y'all already probably know. So I'm just gonna refresh because we have about 15 minutes or so. Hold on. I gotta clean that up anyway. Okay. So let me see. Day 1, remember we had Dolph's sister as the identification witness. We had Raul Hopkins, okay, which was the security for Young Dolph, who basically set the foundation that the whole beef between PRE and CMG was over music. He went into the multiple shootings that took place. Then we went into Cornelius Smith, the junkie, okay, turned killer. Opening statement set the foundation for what the state case is. And according to them, they wanted to hone in on Govan being a person who made the choice to put all this together and that he should suffer his consequences, okay, for those choices. Now, out of all those witnesses, okay, on day 1, we ain't got to a choice yet. However, day 2, they did a little better, okay? We had Angela Arnold, who is Cornelius Smith's girlfriend, who basically said, hey, I saw with my own eyes Govan meet Smith after the shooting at Pressure World or something like that. Was it Pressure World? So that was a big piece for the state. She also said, I know for a fact that Cornelius Smith went to AutoZone to buy a car cover. Why did he buy a car cover? She said, I don't know. But that's a big piece for the state. Good morning, Sig. All right. So, Terrence Dabney, the lead investigator on the homicide, he said in his reports early on in the investigation is that Juke was the mastermind behind the whole play. He also said they never made it to the point they could speak with Juke. The next witness was the cell phone analyst person. He really didn't say much other than confirming what he collected and who number is who. Okay, so I will say the star of the day was definitely Jesse Brown, who was the investigator on the homicide. Now, it got rough in there with old Jesse, okay? But nevertheless, his breakdown was real good. His breakdown was real good for the state because he tied in really when did the conspiracy start. So I'm going to start with how good Jesse Brown was for the state. Then I'll get into how the defense did cause some little, So Jesse Brown basically was able, based off phone records, to pinpoint that as of before 9 p.m. on July 27, 2021, that Straight Drop did not have a connection to Juke. That before 9 p.m. on July 27, 2021, the only people that he knew was Govan and somebody named Ham. Okay? Govan texted him first, the location address, which turned out to be Juke's business. Ham texted him next, an hour later, and said, hey, I'm talking to Juke. Then all of a sudden at 9:08, he is then introduced with Juke by either Govan or Ham, depending on which way your brain want to go. Okay. The very next day, Straight Drop, guess what? Goes off with two other people to try to take out Paper Route Wu. Now, if we fast forward to August 13th, Paper Route Wu is again shot at. But this time is by Bobby Carter and Cornelius Smith. So it seems from the state perspective, everything at that meeting was about the hits. The meeting on July 27th. Now, this is where the defense comes into play, right? Where I feel like, okay, the defense poked enough holes in the situation because the defense is like, all right, so if Straight Drop and others was trying to take out Paper Route Wu, right? Then how can you prove who sent them on that mission when Cornelius Smith only said Govan sent him on the mission later, which was 2 weeks after the original shooting, right? They also showed that, guess what? Hold on, what else? They also showed that Straight Drop was talking to other people about going after PRE artists. So again, it does make you think like, well, did they really need Govan or not? But nevertheless, it does make you think like, why was all them at that meeting on July 27th? Something else that the phone record showed was that the night before Young Dolph was murdered, Justin and Juke talked on the phone for 6 minutes. And at 4:37, Justin sent a turkey emoji to Juke. And the bombshell was that we finally clarified why 2 years ago, all the YouTubers start saying that Juke was picked up by the feds at the airport. It was because Memphis police served him a search warrant for his phone, but he refused to be questioned or anything like that. So we finally found that piece out thanks to Mr. Jesse. And that's kind of where we stopped at. So today we're supposed to start with the rebuttal for the state for Jesse Brown, which is the investigator, and then we'll go from there. I think I summed that up pretty well. Then we go from there. Y'all know I take my little notes. Cause like, listen, I'm gonna tell y'all, doing all types of stuff throughout the day and trying to focus on this, you miss some stuff. So I be having to write it down, okay? I be having to write it down. All right. So y'all make sure y'all hit the like button, share the live. Like I said, thank you to everybody that has been sending donations this week, super chat, super stickers. I appreciate it all. But for those who are not able, maybe you wish you could donate to the channel. All I need for you to do is like, share the live, subscribe to the channel so you can jump in the comments and keep the comments moving all day. Okay? That's the best support that costs nothing that you can do for this channel is just keep the comments moving. Okay? Only thing I will say is y'all no cuss words in the chat. Y'all can spell it a different way, that's fine, but actual cuss words, no, because then support means nothing if they're not going to even monetize my live, okay? So all my mods, I need y'all, if you see a cuss word, put them in timeout for like an hour. That's your warning. If you cuss again, I got to block you because, I mean, obviously you ain't trying to support me for real, okay? See, say, how is school going? School is going great. I'm doing homework now. Yeah, this class kind of kicking my tail, but you know, we gonna work it out. We got some technical difficulties with some of these assignments. But that's about it. So, yeah, that's pretty much where we at, man. Good morning, Ed. Ed said, hey, what happens with Cornelius? I'm still trying to figure out what happened to him. So if you have not watched my video or if you was not on my live last night and the later part of the live, I got an email from VineLink. If you don't know what VineLink is, a lot of states use VineLink so that you can keep up with people that catch cases, go to jail. You can kind of keep up with them. They use VineLink for victims so that you can get immediately notified when somebody is released from jail. I got an email last night while on live saying that Cornelius Smith was released from Dyer County jail. Now, where did he go? I don't know. A lot of people was like, I had to cuss a couple people out in the chat under the video. Like they're saying, oh, it's cat. Like how? Like the email says what it is. People saying, oh, he getting sent to PC. VineLink ain't that type of service. VineLink is made to keep the community aware of what's going on with releasees, detainees. They're not gonna freaking send you an email saying that he was released if he was just going within the jail to PC. That's not how it works. Like I told y'all last night, I got an email on the 13th telling me that Justin Johnson was moved from one prison to another prison. Like that's what VineLink is for. It tells you the movement. If a prisoner is released from one place, it's going to tell you their movement. They're not going to say he was released from custody just because he went to PC. Now, could he have been moved to another facility? That is possible. Possible. I mean, that's possible. But all that, oh, he got moved to PC, that makes no sense. I know for those that's really into it, y'all know we have been using VineLink since the takeoff case. Like VineLink is not that type of service to just be talking like they're not gonna do that. But I haven't confirmed what's going on with Cornelius. I say all that to say I haven't confirmed what's going on with Cornelius Smith yet, if he was moved somewhere else or whatever. Unfortunately, Tennessee is not as accessible as other states like Texas, Georgia, Florida, stuff like that. But we're working on it. Hopefully in a few, I'll be able to tell you more, but we're pretty much at the same pace. I did see a Cornelius Smith enter the system again at a different location. However, it's a different birthday. So that's why I say I'm still working on it. Okay. So I'll let y'all know. Like I said, as of right now, if you check his status, and again, I have been following Cornelius Smith since the beginning. Okay. Lamar said his junkie ass ain't free. I mean, as of right now, he free. Free where? I don't know. Like, I mean, look, I get y'all sentiments. I'm telling y'all, and I showed y'all what the email said. Like, look, take it over to Tennessee, okay? Because we searched it on live in real time. He was gone. Like I said, did he get released home? I don't know. Did he get a bond? I don't know. Did he just get moved to another facility? I don't know. He hasn't popped back up in another facility unless they send him to another state. So it's basically what I'm saying. As I told y'all in the video, it's kind of like keeping y'all abreast of what came out, all the ins and the outs. I mean, once I get the ins and the outs and I can confirm whatever, I'll let y'all know. But y'all do understand it's not like, like it's not even nowhere to call to figure it out right now. Because if he's not in the detention center where he was listed for the past few years, like, but hey, feel free to do your own little 1-2s. And if you find out something, let me know. But that's just kind of where we're at with that. I really ain't got too much more to say about that. That's just where we're at. I was working on it this morning before I started the live, but like I said, I haven't been able to find nothing more. Like I said, the name that popped up entering somewhere else don't have the same birthday. And one thing about Violent, they will attach all your cases. So like for those who's like, well, how do you know is that Cornelius Smith? And like I said, since 2022, I have had Violent for a lot of these cases because I wasn't sure what I was gonna cover. So they link all the cases together. So like the person named Cornelius Smith, right, in Dyer County had the Shelby County case. So it's like they link it together. Ed said he never had a sentencing like Justin has. He no. And like I said, if he got released, it was either on some bond release type stuff or something. Like, I don't know. He could just get moved, y'all. Like, I think y'all thinking too hard about it. But it's just like it happened on live. So it was like, fuck it, it's out there now because it happened on live. But we'll see. We will see. Let me see if the thing is gonna help me today. What? Like, how are you gonna ask me if I'm human? Like, that's gonna just be tripping me out when these computers ask me or ask us, are we human? Are you human? Like, what you talking about? Let me see if it's gonna do something for me today. I might be wobbling. It's still not doing that for me today. My Wi-Fi must be janky today because it's taking a long time. Emmanuel says, I have a question. Didn't Smith say Govan provided him the gun for the paper route Woo situation? I know the blogs, and I talked to a couple of the blogs that I actually have a personal connection with, and they took it down, but a lot of the blogs ran with, oh, he provided the guns in the Adolph murder. That's not true. He said Govan provided him the gun in the paper route Woo shooting, and Justin Johnson provided him the gun in the Dolph shooting. Buzztown said Cornelius hasn't been sentenced yet. He testifying to get a deal during sentencing. I mean, he ain't even took a deal yet. He's telling just on a hope that he can get something. Y'all do understand that. I was looking into that yesterday. He hasn't even taken a deal yet. He's doing this of his own free will at this point. I think they about to start, y'all, so y'all already know how it go. I'll be in the chat. I'm doing homework, and then I got some work to do. But I'll be right in the chat, and we'll get back into it on the next break, okay?
The Honorable Judge Jennifer Johnson Mitchell presiding. You may be seated.
All right.
Dean?
Yes.
Can you cut the feed for a minute?
What's that?
Can you cut the feed for a minute?
Yeah.
I just got some regular work.
Dang, they just came on. All right. So I'm trying to figure out why I can't do that on my freaking page. I don't like that. All right, so we're waiting on them to come back. I'll be working still on the back end, trying to figure out exactly if I can provide y'all a little bit more details about exactly why was he released, and if he was released, did he get released, or he's somewhere else. I'll be working on that on the back end. Like I told y'all, look, Violink ain't the type of service that's just going to say somebody got out, because a lot of victims are signed up for that too. So it's not that type of service, y'all. And if you have ever worked with Violink before, then you know that. So it's not gonna scare a victim, because again, the victims are signed up for it. Victims advocates sign up for that. They're not just gonna do that. Okay, so just FYI, because even on Instagram, a lot of people were saying, "Oh, is this?" No, that's not how Violink works. Mickey, Cornelius has a court date on the 26th. What does that mean? You say that to say what? That he couldn't have got out? I'm kind of confused on that one. All right, hold on, because I'm trying to do something else. I ain't looking at the screen. Damo said, dang, he out. Hey, as of right now, according to that email, he out. He ain't in there, but I'm working on it to see what I can find. And I'll let y'all know. Loud Pat, good morning, good morning, good morning. We can see if he walks in court from the free world. If they stream it, that's a possibility too. If they stream it, but I'm pretty sure I'll find out if he's back in a jail somewhere before the 26th. So like if he is just moved, eventually they got to put him back in the system. So yeah, I don't think we got to wait that long, but hey, that's a point too. That is a point. Loud Pack, I'm about to block your ass. About to block you expeditiously. Y'all make sure y'all hit the like button, share the live, share the live. I hate when they do this so early in the morning, because like I don't even be ready to talk. I ain't even had breakfast yet, man. I don't be wanting to talk this early in the morning. Raymond, good morning, good morning. Shout out to everybody for pulling up. I like to see familiar faces pull up that been here from day one, because we in this together, okay? In this together. All right, let me see. Matter of fact, Darren, what's I need to confirm Straight Drop birthday. Not Straight Drop, Cornelius Smith birthday. God help. Good morning, DT. Good morning, Big City Man. October 20th, Big City Man. Good morning, Pat. Good morning, Kimbella Roxy. Y'all make sure y'all subscribe to the channel. What just happened? Why the screen black? Oh, they doing something on there. Good morning, Kiki. Got the day ones in here. Okay. Y'all been here since Monday. And y'all already know, make sure you keep the chat going. Keep the chat going. Yeah, I definitely got to figure this out, okay? I appreciate it. I try. Well, I be tired, but I be trying. Y'all know the first half of the live, I be at work. Then I forgot to tell y'all, okay, towards the end of court today, I probably won't be online. My grandbaby got open house, and y'all know I'm a hands-on grandma, okay? So I'm definitely pulling up to the open house. So if they go a little too long tonight, I probably won't be doing a closing or a recap. Just FYI, just letting y'all know early. Good morning, Nikki. Nikki was on it yesterday, okay? Because I had none. Listen, I had my ADHD hadn't kicked in. I had none like went blank with paying attention. But she been paying attention, okay? And she kept us in there, all right? Kiki said Memphis real messed up quick, might get a mistrial. I'm telling you, look, I'm just telling you, it's a lot. Like I will say, y'all, it was some good points in the phone records, but at the same time, the phone records was like a wild card, depending on how you look at it. So it's gonna really be up to each juror. Kim Bella said, "Have my breakfast and ready to talk ish." Okay, yeah, we got to keep these comments going. All right, let me see. Yeah, I think this is the right person for sure, without a doubt, y'all. All right, so this is what I'm gonna say. I'm about to show y'all something real quick. So I don't like see YouTube so funny. You know what I'm saying? Listen, YouTube so funny. All right, this is what I'm saying, because Vine link is open for anybody to go look at. Okay. So what I want y'all to do, those that's really trying to figure this out with me. If you go to Vine link to Tennessee, type in Cornelius Smith, okay? When you type in Cornelius Smith, a bunch of Cornelius Smiths gonna pop up. But if you go to the one, okay, that has a Shelby County arrest from January 11, 2022, which is when he was indicted, okay? Go to that one. It's going to say he was moved, or it's going to say he was basically unsupervised custody, right? As of September 27, 2024. But then it's going to have another link, okay, to Dyer County, where it's going to say from that date to August 19th. That's how you can confirm it's him. And like I said, I haven't seen him pop back up. Okay, so just FYI, for those that's on this hunt with me, let me print this. No, let me save it. I'm gonna save it because YouTube be real funny when you post people birthdays and stuff. All of them. Finally, not gonna tell you he out if he in witness protection, and if he is in witness protection, meaning out of jail, I mean he's still out. Just FYI, y'all.
Okay, so. Make sure I have this right. State moves to use the CDRs for, what's TZ's government name?
Joshua Taylor.
And the other person,
Harry Lockhart.
who's also referred to as Ham. Harry Lockhart.
Harry, Harry.
TRE
I have no idea.
or?
I don't believe so. I've seen no evidence of that.
So Ham doesn't necessarily have an affiliation here.
Correct.
I was asking if Ham had an affiliation with TRE or CMG. No, nobody really knows. Okay, that's fine. Okay. So let's take them in reverse just because that's kind of how I looked at them. Ms. Taylor, what's the argument again for the court to allow in the CDRs for Harry Lockhart, also known as Smith?
You're right. He was referenced in, well, his name was brought up as having communication with one of the co-conspirators in
Which one?
Justin Johnson.
His name was brought up in text messages or?
No, his
testimony?
name was brought up in Browning's testimony on yesterday.
Okay, as what? I mean,
As having, this was on July 27th. It was in reference to Justin texting him about talking to Juke, and it's also, I believe, relevant as to the text messages that defense has brought in referencing his name. They indicated that Justin was doing, Joshua Taylor, Harry Lockhart, all the names starting to get confusing. Harry Lockhart was talking or was referenced in some of Justin's text messages in regards to maybe Justin doing an outside thing, outside of the conspiracy.
and you said specifically on July 27th,
Yes,
as we were going through text messages on yesterday?
no, he was brought up in Browning's testimony
Right.
in regards to July 27th.
So what I'm saying is that did we not see text messages yesterday from July 27th?
Just from Justin Johnson.
Well, that's what we're talking about. we're talking about Justin Johnson's communications with Harry Lockhart.
On yesterday is how Harry Lockhart became relevant. And it's also referenced in Justin Johnson's text message to, I think, another individual.
About Harry Lockhart. Okay, so my question to you is that when Sergeant Browning was testifying yesterday going through his PowerPoint, was Harry Lockhart mentioned on the 27th? Did you because you referenced the 27th?
Yes.
That's what I'm saying.
Yes.
And you think it's relevant now, because I'm sure that's what your argument is going to be. I didn't necessarily get that from you. Is your argument that it's not relevant?
Yes, Your Honor, just like yesterday, it's just a passing reference to the text. There's no communication that we introduced to him, and you suppressed that yesterday because that's the whole point.
I got that, and I agree with what I just read, that it is just passing here. Ms. Taylor just brought up another argument, but that it was brought up in Sergeant Browning's testimony yesterday that there were conversations on text message from Justin Johnson to Harry Lockhart that she says is relevant because Harry Lockhart's name came up yesterday.
Right, it was on direct. They brought it up. It just happened.
All right, because I see my people confused too. Okay, so real quick, I paused it real quick. Harry Lockhart is Ham. If you remember when the state was breaking down the PowerPoint with Jesse Brown, the Memphis police detective, right? They said at 7:37, Govan sent dropped the address to Big Juke's business. At 8 something, somebody by the name of Ham, aka Harry Lockhart, text drop saying, I'm talking to Juke. Then at 9:08 p.m., Juke and Drop put each other numbers in their phone. So the state was trying to prove that Govan was the connection, but they also threw Ham in there where the jury could think that Ham could have been the connection as far as introducing Juke and Drop, just to clean it up.
Happens to be a passing thing on cross that we're doing a text message. You can white it out for all I care. I didn't need his name in there. I'm just giving you the text message because Justin Johnson was talking to somebody else and he says, oh, Ham's there too. That's essentially all that is to it. It wasn't relevant and direct when they talked about it yesterday. We didn't bring it up. We didn't emphasize it. We didn't do anything. I don't even know what Ham has to do with the price of tea in China.
But it's now in the text messages that you've entered.
His name,
That's to say that you highlighted some text messages, okay?
Right.
That says that you're making the argument that Justin Johnson was having individual conversations outside of Govan, Mr. Govan, about other issues, about
I'm not,
whatever they were talking about.
I'm not highlighting it.
No, you're highlighting.
Well, it's in there, but on direct, they brought it up, that Justin Johnson.
And I understand, but you've now highlighted it, and so, Ms. Taylor, what's your response that it's not relevant here, that it can be whited out as far as he's concerned?
Well, now they want it whited out. They didn't do that yesterday, and they could have done that then. But also, Your Honor, I would further state that there are communications between Mr. Govan and Mr. Lockhart during the time of this conspiracy, which I think is relevant. And if they're gonna bring it up that Justin, may have been doing some outside things, it's important for the jury to also know that Mr. Lockhart had communications with Mr. Govan.
Judge, they brought up the communication between Justin Johnson and him. They brought it up in their text message.
On the
It was
PowerPoint.
already there. So when I'm crossing in with some of these other text messages, that guy's name is referenced. We didn't bring any other specific text messages between him and Justin Johnson. They brought it up. It wasn't relevant to them yesterday when they went through a very lengthy direct examination. It's one of their slides out there that says Justin Johnson talked to him. They brought it up. I didn't even ask the name Ham. I just read the text message like you instructed me to do and admitted this stuff. It has nothing to do with anything as far as that goes. They brought it up. And I'm just responding to that. It wasn't relevant in direct examination, but now it's relevant.
What's your
I mean,
response?
I reiterated that, I mean, the call records aren't coming in through another witness. These are self-authenticating documents that I feel are relevant to this trial, specifically to Mr. Govan. If their argument is gonna be, which they asserted several times yesterday, that Justin Johnson was going outside this and he was talking about Ham and referencing Ham and sending information about Juke to Ham, it's also relevant that Ham or Mr. Lockhart has communications with Govan. It's not outside of the scope of the conspiracy.
Your Honor, they're conflating the issues. They brought up the fact that Justin Johnson was talking to Ham on direct examination outside the scope of the conspiracy. My text messages don't have any communication with Ham. It's through somebody else. If they want to bring in the TZ stuff, I agree. I put in a text between Justin Johnson and TZ. Got it. It's the same argument we went through yesterday on chat. They brought up the text. Now she's making it seem like we somehow manufactured something out there. They brought up the text, indirect, that Ham communicated with Justin Johnson.
Good job, Manny.
And I was under the impression that Ham was mentioned, and I'm looking at exhibit 26, that Ham was mentioned in this text message from Justin Johnson to TZ, Joshua Taylor. I'm going to exclude that one. As to Harry Lockhart, also known as Ham. You cannot use those.
We have no objection to the TZ one, Your Honor, based on that argument.
All right. So you can use the TZ, Joshua Taylor CDR. Thank you. Anything else?
Not for Mr. Govan, Your Honor.
Say that again.
Nothing for Mr. Govan.
I'm sorry. All right, we ready to bring in the jury?
Yes, Your Honor.
Is your medical examiner here?
Yes, sure.
I want to put her on.
Well, I will just say I have no further questions for Sergeant Brown.
Okay.
I don't know here.
Yeah, he can be released and then bring in the medical examiner. And we'll just let the jury know that he's been released.
And
All right, because I had a phone call come in. Did they throw out even the text message that they had on the slideshow too of Ham, or just the text messages that came in later with the TZ situation? I didn't hear that part. I was on the phone. And also, yeah, I was just about to say that, Kiki, because like they needed to clean up. Why did Justin Johnson only text Juke the turkey emoji and all that instead of texting Govan? Just saying. Okay. Jesse Brown won't get on the stand. Medical examiner is next, so we'll see where it goes. Personally, I don't think like the medical examiner is gonna really be like really, cause it's established that Young Dolph is deceased. But you know.
Ready, Your Honor?
Yes.
Jury's now in.
Good morning.
Morning.
Before we call our next witness, you should know that Sergeant Browning was excused, yesterday without any further questions. Call your next witness.
The state calls Dr. Juliet Spindleberry.
Stand right here, ma'am. Face you, Honor. Raise your right hand, please.
Do you swear or affirm to tell the truth?
I do.
Have a seat. Thank you for your presence this morning.
Good morning.
Good morning.
Could you state and spell your name for the record?
My name is Dr. Juliet Scandleberry, Julietttb, Scandleberry, Scandlebury.
And where are you employed?
At University of Tennessee, at a West Tennessee Regional Forensic Center.
And what's your position?
I'm an assistant medical examiner,
How long have you been in that position?
6 years.
And what does your job consist of?
My job consists of performing medical legal autopsies to determine cause and manner of death in certain cases in this jurisdiction.
I want to talk a little bit about your background. Could you tell the jury about your education?
Yes. So I completed a Bachelor of Science in Biology at Howard University. Then I completed my medical degree at Howard University College of Medicine. My anatomic and clinical pathology residency was at Washington University in St. Louis. And then my last training was in forensic pathology fellowship at Salinas University.
And are you board certified?
I am.
And are you a licensed physician in Tennessee?
I am.
And could you tell the jury what is forensic pathology?
So forensic pathology is a specialized branch of medicine that examines deceased persons to determine the cause and manner of death in a medical legal approach.
So what does a forensic pathologist do?
So a forensic pathologist performs autopsies based on the jurisdiction that they're working in to determine the cause and manner of death for certain types of cases that are under our purview.
And what exactly is an autopsy?
So an autopsy is an extensive examination of a deceased person. They have an external examination and an internal examination of the body. So you look at everything from hair color, eye color, their body habitus, see if they have any scars, tattoos. That's external examination. And then the internal examination, depending on the level of autopsy, we'll look at all body cavities, we'll weigh all organs, we'll see if there's any fluid or any evidence of disease in any organs. And we also went ahead and look at the brain and we take certain fluids to be able to test to determine by toxicology or histology to determine, and with all that together, we determine what most likely caused the death for a person if we do an autopsy.
So Dr. Scantleberry, are there different stages of an autopsy?
Yes.
And what are those stages?
Okay, autopsy itself is looking at the body, but starts from the investigation. So the investigator will give us some information, and the information we get from the investigator determine what type of autopsy we need to do. And if there's determined that a full autopsy needs to be performed, we might need x-rays, we do that first. Someone will help take all the clothing off, if there are any, take necessary pictures, necessary measurements of the body, the height, weight, and any other identifying characteristics on the body, and then move on to the internal part, and that's where we'll make an incision to open up the body cavity to see the internal cavity and see all the organs and any changes that might have happened that might be related to death or otherwise.
And have you performed an autopsy before?
I have.
About how many would you say?
Over 2,000, I stopped counting after that.
So could you explain to the jury, what does cause of death mean?
So cause of death is the immediate reason that led to a person's death. So it may have different ways of saying, so if it's natural, it will be what medical disease led to the person's death, or if there's any kind of injury that caused the person to no longer be alive.
And is that different from manner of death?
Yes.
How is it different?
So manner of death is the classification of that type of death it was. So it will be how you would want to classify the death. So there are 5 manners of death in this jurisdiction. It may vary in places, but here is natural, accident, suicide, homicide, and undetermined.
And have you ever testified about your findings from an autopsy you did?
Yes.
And have you ever been qualified as an expert witness in the area of forensic pathology?
I have.
And have you been qualified in the courts of this county and other counties?
I have.
Where have you been qualified before?
Illinois, Missouri, and Tennessee.
Your Honor, I tendered Dr. Scantleberry as an expert in forensic pathology and asked that she be allowed to state her opinions as to a reasonable degree of certainty, medical certainty.
No objection.
The court will, find that Dr. Scantleberry is an expert in the area of forensic pathology, therefore she can testify as to how many of the opinions as to that matter.
Thank you. Dr. Scantleberry, I want to ask you about a specific autopsy. Did you perform an autopsy for an Adolph Thornton Jr.?
I did.
Okay. And do you recall when this autopsy was performed?
Yes.
When was it performed?
November 18th, 2021.
Okay. And during the course of conducting this autopsy, did you also take pictures of Mr. Thornton's body?
Pictures were taken.
Okay.
No objection, David.
Okay. I'm passing you a few of the pictures from this autopsy. Dr. Scantleberry, do you recognize the photographs we just handed you?
I do.
Okay. And do they accurately depict the victim and the evidence during the autopsy?
They do.
Okay. Your Honor, I would like to have these photos of the autopsy entered into evidence and marked as index number exhibit.
Well, she needs to testify about what they are.
If we could enter them as a collective exhibit.
Well, that's fine, but she still, for the record, we need to know what they are. She needs to testify to each of them individually.
Okay.
I mean, you don't have to publish them, that makes me no difference, but she needs to tell us what each one of them is.
Dr. Scantleberry, if you would look at that first picture, what is shown in that first picture?
So this first picture shows the Mr. Thornton on the right side of his body, but some of his head and his right shoulder, and it shows some gunshot wounds of his right jaw, right neck, and right shoulder.
What about the second picture?
This is a shot of his right upper extremity of gunshot wounds of the right forearm, so here and here.
What about the third picture?
This is another shot of the right side of his body, mostly with the right arm, and it shows his right hand, and there's a gunshot wound of his right wrist, and it shows another gunshot wound of his right forearm.
And as to the fourth picture,
This shows some other gunshot wounds of his left upper extremity.
and the fifth picture.
So this picture shows the back of Mr. Thornton's body, and you can see both arms and his back, and you can see the majority of the gunshot wounds of the back, and you can also see some gunshot wounds of his upper extremities.
And the sixth picture,
This is another picture showing the same thing, but it was taken from the left side of the body, showing gunshot wounds of the back and upper extremities.
and the seventh picture,
This is a closer view of the gunshot wounds of the back from the left side of the body.
and the eighth picture,
This is an overall view of the bullet fragments that were recovered from the right jaw from Mr. Thornton.
and the ninth picture,
These are bullet fragments from the torso from Mr. Thornton, pictures of bullet fragments.
and the 10th photo,
This is shows a picture of the remote bullet from the left thigh.
and the 11th,
This is a remote bullet from the right lobe of the liver.
and the 12th,
This is a bullet core fragment from the right chest.
the 13th,
This is a bullet from the lower mid back.
the 14th,
And this is a remote bullet from the right buttock.
Your Honor, we'd like to have these photos of the autopsy entered as a collective exhibit.
No objection to any of that.
We're gonna make this a collective exhibit. Pages. The first 7 pages are multiple pictures of Mr. Thornton's body with multiple gunshot wounds. The next 7 are pictures of the fragments that were removed from different parts of his body. We'll mark this as collective exhibit 31.
Thank you. And we have permission to publish?
Yes.
Dr. Scantleberry, we're going to start with the first photo that you viewed. Could you tell us what is seen in this photo?
So in this photo, you see the right side of Mr. Thornton's body. That rectangular object is the case placard with the case number associated with this case. It can be seen. This will help you attach that photo to that particular case. And it can also use the scale for the wounds or anything you need to measure on the body. So on the right side of the body, you see those defects in his right jaw and right neck. Those are gunshot wounds of his right neck and right jaw. And then there's some gunshot related injuries of the right shoulder.
Did you have any specific findings as to this injuries?
Yes.
What were those findings?
So the injuries of the right jaw and the right neck cause injury to the tongue and skeletal muscle and the right mandible, which is the lower part of your jaw. Those were injured.
Moving on to the second photo that you viewed. What is shown in this photo?
This is the photo of his right arm. So to the right of the image, that is his right arm. and most of what you can see is right forearm, and this is the front side of it, the anterior portion. You can see those two large defects are gunshot wounds.
Were there exit wounds on this part of his body?
Not that one. Those are kind of graze or tangential wounds.
Moving on to the third picture. And what is shown? What is shown in this picture?
This is a photo of the right side of the body, and you can see a gunshot wound in the right wrist, and another defect a little earlier, a smaller defect.
Moving on to the fourth picture. Could you tell the jury what we see in this photo?
So this is a photo of Mr. Thornton's left forearm, and it shows a gunshot wound and some gunshot-related injuries of the left forearm.
Moving on to the fifth photo. What do we see in this photo?
So this is the backward view of Mr. Thornton. His head is to the right and his feet are to the left of the photo. And you can see his arms, you can see some of the same gunshot wounds you saw in previous photos, but on the back view, you can see the overall view of the gunshot wounds of the back.
Okay. And moving on to the sixth photo.
This is similar, but from the left approach of the body. You can see its overall view of the gunshot wounds of the left, of the back.
And the seventh photo that you do?
This is a closer view of the gunshot wounds of the back from the left side of the body.
Okay. So in total, how many gunshot entrance wounds were there on Mr. Thornton?
Definitive gunshot entrance wounds, 20.
And were there any exit wounds?
Definitive exits, 4.
Okay. And moving on to the eighth photo. What do we see in this photo?
So these are bullet fragments of the right jaw. These are all the larger fragments that were able to be recovered from those wounds that you saw in the right neck and jaw.
And that was from the first photo that we viewed?
Yes.
Okay. And the ninth photo?
These are fragments recovered from the torso.
Okay. And the 10th?
This is a remote bullet from the left thigh.
All right, and the 11th photo?
This is a remote bullet from the right lobe of the liver.
Okay. And the 12th photo?
This is a bullet core fragment recovered from the right chest.
And the 13th photo?
This is a bullet from the lower mid-back.
And the 14th photo, what do we see here?
This is the underside of a bullet base that was remote, that was recovered from the right buttock.
Can you describe to the jury, what is a remote bullet?
So remote is people use different words can say remote or old, but I choose to use remote. Remote means it's a bullet that is related to a previous injury, a previous shooting, not the shooting that led to their death in this case. It's happened before.
Okay. And how many, or do you recall how many remote bullets you might have found?
There were 3.
Okay. So, Dr. Scantlebury, within a reasonable degree of medical certainty, did you render an opinion as to Mr. Thornton's cause of death?
I did.
And what was that opinion?
Gunshot wounds of the head, neck, and torso.
And did you render an opinion as to the manner of death?
I did.
And what was that opinion?
Homicide.
Your Honor, I will pass the witness.
No questions, Your Honor. Thank you, Dr. Scantlebury.
Thank you, Dr. Call your next witness.
Your Honor, that is the state's proof, with the exception of the,
Go ahead and read that.
Is it something that you wanted us to read into evidence? This was just a stipulation.
Oh, that wasn't a stipulation.
No, it was.
You don't stipulate to the phone record, it's no problem.
Did we already put it in the evidence?
No,
We
no.
talked about it. We have put it in the evidence. So ladies and gentlemen, when you go back to deliberation, you will have everything that's been entered as an exhibit. There are at least two documents or two exhibits that you haven't necessarily heard specific proof about. They are called, what you might have heard is CDRs, called detail records. The law will allow certain records to be entered into evidence without testimony about them. And so that's what Ms. Taylor is getting ready to enter into evidence now. It's been redefined by the state, and there was one that was entered yesterday also. So you'll have a few things that you can review, but you haven't necessarily heard testimony about.
Attached is the self-authenticating document and the flash.
Now this is self-authenticating document for phone number 901-283-3878. From T-Mobile, attested to by a Joe Rico. Also I have here is a zip drive, a blue zip drive that has Joshua Taylor's name on the outside of the envelope, and it has CDR. So these are the call detail records for one Joshua Taylor. Let's enter this as collective exhibit 32. So Ms. Taylor, do you officially want to rest or?
On the debt is the state's.
Thank you. Ladies and gentlemen, we need to take a brief break. We're coming back in just a few minutes. You haven't heard all the proof. Continue to do what I know you've been doing, which is not talking about this case. Give us a few minutes. We got a few legal things to take care of, and we'll call you back in just a few minutes. Mr. Roy, you have a motion?
Yes, Your Honor. I was moving for a directed verdict, understanding that Mr. Cornelius has given some statements about that he was ordered to do it. I don't know if that rises to the level of a conspiracy or agreement amongst the parties. It was very inconsistent as far as that goes. Secondly, there's been no mention of how Justin Johnson is part of the conspiracy at all whatsoever. I understand it only takes two to tango, but I just don't see where the proof adds up to the conspiracy, and certainly not the first degree murder charge in count 2 based on the evidence that you've got.
Your Honor, the court is to view the evidence in the light most favorable to the state. We've heard testimony from Ms. Thornton that Mr. Thornton, the victim, was alive, is no longer alive. We heard testimony from Dr. Juliet Scantlebury, who testified as to the cause and the manner of death, which is homicide. But we also heard from a few other witnesses, like Cornelius Smith and Angela Arnold, stating that Hernandez Govan is the one that told Smith about this hit on Mr. Thornton and told him about the price. So all that to say, Your Honor, and also, Your Honor, that Justin Johnson was involved and was a part of it. So all that to say, the state would argue that there is enough for a reasonable jury to conclude guilt.
And Your Honor, I have no quibble. Of course, he was alive and he's since passed. I'm just, you heard proof that they didn't communicate for 2 weeks, at least with Justin Johnson, at least 2+ days on the phone calls that the government submitted yesterday. Cornelius Smith, supposed last phone call was on the 15th of November, 2 days prior to the murder. It was for 0 seconds, and then there was that code 11 that Garner talked about, might have been voicemail, that was 40 seconds. We know for a fact that he didn't talk to Justin Johnson based on the phone records for at least 2 weeks prior to the shooting. You're being asked to make a lot of supposition here based on what Cornelius Smith said. Cornelius Smith also said there was no plan. He got a call that morning, they got there, and they were just riding around doing whatever. Now, the fact that somebody 3 to 4 months prior to that fact said to you there may be a price on somebody's head, and was it Justin Johnson? I'm sorry, was it Govan or was it Joke? You've heard both things from the same witnesses have said it both ways in uncontroverted evidence. And so I'm not sure, how do you have a plan when I say, hey, there's a hit on these people. Some point in the future they kill them, now I'm on the hook for it. I just don't see how that makes a conspiracy. Generally, there's been meeting in minds as to how, who, what, when, where. Nothing happened. It was just generic, if you believe Cornelius. 4 months prior to the shooting, there's a generic statement that, hey, there's a hit on these guys and you can get paid.
Anything else? In the light most favorable to the state, the court has heard from different witnesses. There has been some conflicting testimony. However, the court thinks that the state has made a prima facie case for both conspiracy to commit first-degree murder and first-degree murder, and it's a jury question. So I'm going to deny your motion. Are you ready to present proof?
Can I just have a couple minutes to see who's here? I told him 10:30. He said, no,
Let's stay in a brief recess.
Or stands in a brief recess. I'm on mute. All right. So basically, the defense wanted to bypass the jury and wanted the judge just to rule in their favor that the state didn't prove their case. So although the judge said, hey, it has been some conflicting testimony, but it's enough there where a jury with instruction should be able to come to a decision. So it's left to the jury. The state technically has rested. Then when they come back from the recess, we will be going into the defense case that they're going to be presenting. And then probably by the end of the day, early tomorrow, it'll be deliberation, charge the jury in deliberation. So yeah, it made sense though for the judge to deny that request. I mean, it was worth the shot. Because like I said, and y'all know I have been telling y'all since day one, I just don't see the state's whole storyline. It fell apart. However, they did have some reasonable with the phone record. That was a biggest thing as far as Govan, right? But they also had some shaky stuff with those phone records, okay? Because at the end of the day, on your PowerPoint, and they argued about this in the beginning, your PowerPoint, you show Govan texting straight drop an address, but then you also show him saying that he was talking to Jook, and then 30 minutes after him texts him that now straight drop and Jook is saving their phone number. So it does kind of leave it like, okay, well, why would you put that in there? Because without that, it would have looked like Govan introduced straight drop to Jook. But with that extra message from him, it's like, it's up to you which one you want to believe. So like I said, I feel like they had, because some people may overlook the little things as far as the phone record. So they may be able to get over it. So it's just gonna be up to, the jury. The medical examiner gonna help in the state defense. I mean, the point of the medical examiner is to put that emotional part of it, because at the end of the day, we know this is a murder trial. So they're there just to confirm, like, hey, because he is charged with murder. Like, hey, this guy was murdered, and this is how he was murdered. And it sounded brutal, like, for sure. So, yeah, they definitely had to play down. Like, what's going on? What's going on? All right. So yeah. Govan was still the middleman, though. They had no access to Juke. Sounds like Govan conspired and was to connect. I'm gonna disagree with you, Ebony. It's so many different ways. It seemed like Straight Drop didn't have access to Juke originally, but he at least knew people who did. So they haven't proved without a doubt that Govan was the connect, because like I said, the ham guy, let's not forget Teasy, you know, so like that's why the whole debate in the beginning about bringing these extra phone records of Teasy and Ham was being debated, because those were also connections to Juke that Straight Drop had. Phone records. So well, I just missed it. The phone records were more about who is locked up. Straight Drop, Juke dead, and the other three were not indicted. They did have access to Juke. Lamar said case trash, but they're gonna vote guilty though. I don't know. You gotta have more faith in it. I mean, like I said, if I was on the jury, okay, if I was on the jury, I would definitely be either the reason it would be a hung jury or it would be not guilty, because I just don't see it. I saw it with phone records and then boom. And like I said, by the state not coming back and cleaning up why the night before Dolph was killed, Straight Drop was texting and talking to Juke only and not Govan, makes me feel like Juke put Drop on it. You know what I'm saying? So he's out on bond. My bad, I got a client call coming up soon. But yeah, so they called Juke after they did the job. Cornelius did not have access to Juke, was dropped dead. All right. So, like I said, at the end of the day, without a doubt, Cornelius, okay, like I said, I was up in the air as far as I'm still not believing the whole context of the meeting or the interaction at Govan house that actually occurred. However, without a doubt, the defense did not challenge that Cornelius Smith didn't meet Juke at Govan's house. So I do feel like Govan introduced Cornelius to Juke. However, I feel like after that point, Juke put Smith with Justin Johnson. I feel like everything after that point was just them. And I say that because, and I said it yesterday, I say that because Justin Johnson, aka Straight Drop, was contacting Juke with all the updates. Turkey emoji, talking for a long period of time the night before. He was the one that provided the weapons for the Dolph head. Soon as it was over, he FaceTimed Juke saying, spitting out Dolph. Like all of that. Some of y'all may be like, well, Smith was still calling Govan. Well, Smith also said he was buying drugs, pills from Govan. So they haven't proved that the conversation was anything other than pills. You know what I'm saying? So I just don't see it. It's just me personally. I think if they don't find him guilty, someone's going to kill him anyway. I mean, y'all say that with every case. I mean, they could not. I mean, he been walking around this long, ain't nothing happened to him, you know. States that all will communicate with each other, but again, it's context is key. Okay, context is key. So if you got Cornelius Smith already admitting that he was buying drugs from Govan forever, okay, then him communicating, obviously he's a bad junkie, okay? He said it himself. Like, so it makes sense for him to keep in contact with Govan. This is the thing. They haven't provided that their conversations were anything else other than drugs. When the defense asked Smith, where did he get the pills and stuff after he got shot? He wouldn't say. He wouldn't say. He said, oh, they ain't got nothing to do with it. You was buying your pills from the same person that was buying the pills. Okay? Baltimore said, can we see the video of Govan and Smith behind the car wash building? It's no video. That was the point to bring it up. The point of the defense to bring up the fact that it's video cameras out there at the car wash was to show that the detectives on the investigation did not do a thorough job, because the detectives couldn't even say, hey, well, no, we did ask for the video. However, they said it didn't work. No, they said we never asked for them. We never went. Same thing with AutoZone. They never went. So that was the whole point of bringing that up, is to show how they was not actually doing their job. That was it. It's no video. Pretty sure probably, especially depending on where it's at, probably the cameras didn't work. But the point of the defense highlighting it was to show that they didn't do their job investigating. What else y'all got? Brandon said for him to turn down the plea deal, obviously his attorney convinced him enough that they don't have any physical evidence to convict his client. I ain't gonna say that's the reason why he turned down the plea deal. I don't know what the plea was, but I mean, at the end of the day, if you still facing football numbers, take your chance at trial. This man is what, 40-something, 50-something years old. So if they offer him 30 years, that's still life. Take your chance at trial. You facing life anyway. He's not like he's facing a death penalty. So, I mean, at the end of the day, it's like to each his own, but you got to just think about life expectancy. Like, why would you just settle down for 30 years when you already 50? And if you make it to 80 to even get out, like, it makes no sense. Take his chances at trial. And he's fighting the case from home. Like, so you going to take a plea deal so you can be in a cell in a couple days? Nah, go to trial. Enjoy some more time at home. Because when he get found guilty, they may ask for his bond to be revoked and him to stay in jail. His lawyer can fight or whatever. But it's just, you know. Raymond says, so far, I think Govan may get off. I think if they actually look at it, it's either going to be not guilty or hung. If they come back guilty, they got paid off. I don't care what y'all say, okay? Because there's no way they don't see no reasonable doubt. Now, again, like I told y'all, in the Queso trial, that storyline never, the state just painted their case so clear. Every piece just locked in. The defense tried. I'm talking about the defense was windmilling. They couldn't get it. So I knew that was open and shut. You got to say guilty. But this one, the only storyline that made sense was that he was a fall guy, and that's the defense. So if the defense story make more sense than the state, you got to acquit him. Because at the end of the day, what it seemed like is Straight Drop was trying to do anything to become a musician. Anything. Okay? Anything. He was trying to get on with CMG. So you know what? If my chances to get on a CMG is to take out PRE, I'm going to do that. And that came out in the phone records. So that's that. He also fighting a serious health issue. Yeah, so that's another thing. You ain't going to make it 30 years. So that is, now again, this is just my interpretation and my opinion. And like I said, if I was on the jury, I would definitely vote not guilty. It's nothing you can change at this point because the state has rested. At this point, it's nothing you can say that doesn't still have me like, but it could have been this, you know? Kiki said this is not the end. They needed him to move forward with another case. Kiki, hey, y'all been saying that for 4 years. Hopefully y'all get y'all case. And if y'all get y'all case, hey, we're going to break it down. But, I mean, I don't have nothing else to say about that. Y'all been saying this for years. Mickey, clear this up. Didn't they say during the trial the shooters only knew about the hit from Govan? No, Cornelius Smith said he only knew everything from Govan. But he also said that Juke told him he would get paid for his work. So obviously you ain't know everything from Govan. He also said that Justin Johnson gave him the gun for the Dolph shooting. So you obviously got some information from Justin Johnson. So like the judge said, it is some discrepancy, okay, with this whole storyline, even if you listen to Cornelius Smith. Black Light said, how much money would you do a life sentence for? You sound crazy as hell. What kind of question is that? What kind of question is that? Like, what? Like, what? Black Light, what are you talking about? Are you saying it in terms of like when people do crimes and stuff or whatever, they don't look at it that you could be facing life? Well, the point of it is when people do crimes, just like Cornelius Smith says, the plan is to not get caught. So no, they're not looking at if I go chase this heat money that I'm going to be caught within 30 days. They don't think about that. So, I mean, that's really not a logical question to ask because those people, and it doesn't even have to be murder, scamming, stealing, whatever, they think of short term and the fact that they're going to get away with it. Hence why we have so many people, you know what I'm saying, so many people that turn state and snitch because they don't think of what is a downfall of their actions. They're only thinking about the reward of their actions. Ed said, I feel this is a waste of a witness, but that's just me because what is she proving that Govan did? Just proving because, again, he's still charged with murder. So they still have to prove that he was murdered. That's it. Black Light said, I'm saying that would you do a life sentence for $5 million? That's a dumb. I just feel like that type of question is dumb. I tell y'all straight up, I ain't trying to do no time. But at the end of the day, if I'm faced with a situation where I got to make something shake, then I'll probably make something shake and then have to deal with the consequences later. So to say like, you know what I'm saying? Like, that's just like, you can't ask that type of question. Like, who's going to really say, I'm going to do a life sentence for $5 million? Like, okay, present me $5 million, I'm going to do a life sentence. That's not how it goes. Most of these people be in fucked up situations and they feel like whatever they're about to do is going to change their situation. So I just don't think that's a logical question to ask somebody. That's just me. Excuse my language, I know. But I'm just like, that's just real. Like, you can't, like, when people back are against the walls, is like, it's a different situation. Because just asking somebody that don't have nothing to lose a question, they going to have a different answer than somebody that got a lot to lose. You get what I'm saying? So, like, if that makes sense, that's it. Where we at? Darren said Bobby was the first suspect question, and I think he told on cornbread. I don't think so. Because if he told on cornbread, he would have still needed to be used as a witness. So I don't think so. Y'all still saying he's something like a Titanic? He might be. Hey, if the people on the jury think like y'all, yeah, he definitely done. He's done. Overdone. Okay? Yeah, they call Cornelius cornbread, Ebony. I don't know why the hell they call him that, but that's what they do. They had to stress me out the other day. Okay? Lamar said Govan didn't have hands in it because everyone else besides Justin and Cornelius did. Listen. Well, it seems like the shooters are the only one that made it out. And it might be because the police caught them quick enough. You know, so I don't know, y'all. Like I said, I don't think the state made this case for guilty, but that's just me. Majority of y'all think they did. That's that. Buzztown saying the shooters testifying at Govan set up the meeting. Something. Nah. Y'all got... For one, this is the thing. The state themselves said the meeting technically to put everything in play was July 27th, 2021. We don't know when Cornelius Smith even met Juke, other than it had to be after August 13th when he shot at paper on Route Wu. So did he introduce him? For sure. But all the other evidence they proved since then was that, hey, he may have introduced Juke and Smith, but they were rogue on their own. That's that. Big Wolf, I'm pretty sure Govan guilty, but I just think the state case is a little weak here. Yeah. Like, at the end of the day, me personally, hell yeah, he knew about what the fuck was going on. Most people that run in them circles in the streets, they know about that shit. I'm saying in a court of law, they ain't prove it, though. So don't get it twisted. I'm not agreeing to it. But just in a court of law, this trial, they didn't prove it. But just on a regular thought process without worrying about facts, and yeah, hell yeah, he knew what the fuck was going on. I don't think it was no secret. Cornelius Smith knew what the fuck was going on. All that. Like, you know what I'm saying? Now, his meaning to do it probably was just to get high, but yeah, they knew what was going on. You know. Lamar said exactly. Jail saved the shooters. Everyone else they mentioned that had parts ended up deleted, as the YouTube community said. Bust down, it's just a fact. Legally, he's son. If I introduce someone to someone else to buy drugs, I get the same bust down. No, you don't. But let me guess. You caught a case before, and that's how you know that. That's not how that goes. Just because you introduce somebody to somebody, okay, does not mean you're going to get the same charge, homie. That's not how that works. And if they caught you that way, then guess what? Okay, you might want to get a better lawyer, like on some real stuff. Shout out to Black Butterfly for the super chat. Same Mickey not guilty beyond reason without facts. That's that. Setting that showed it on his IG story last night. Show what? Paper Route Wu has a 911 out of him calling 12 during the shooting. I mean, we don't have to look at Setting Nash story to know that. They said it in court yesterday. Shout out to Setting Nash, but I mean, you ain't even had to look at his story for that. They said it yesterday. They said he refused to give his name, but they said he was being shot at and he needed help. Boy, said it, come get your people, man. Like, y'all be in the comments all day. Do y'all not pay attention to the trial? Like they said that. The hood nigga bloggers definitely are highlighting it because they're saying, I think said it even said he was snitching, you know. But hell, that's not really my area because I mean, it was a bigger situation to how they presented it than that. But, you know, if that's what your mind is on, then yeah. But yeah, they said it in court. Ain't no, you know, ain't nothing. Go look at Reggie, right? Man, I'm not gonna. Why the fuck would I want to go look at his case? Every case is different, y'all, and I don't care about none of that West Coast shit. So no, I'm not gonna look at his case. Like, I'm telling you what I know. That's not how that go. It's way more. It's way more going on than somebody just getting caught up with introducing somebody, and that's a fact. Ask your favorite lawyer, like for real. Like, y'all be needing people that just caught cases to explain shit. I'm telling you what I know. Like, go talk to a actual lawyer and tell them to break down how would you get caught up, whether it's a drug deal or not, as being the middleman. Is more to just you saying, hey, bust this street news. Tap in. You got to be more involved, people. Y'all got to stop playing on my top. Like, my thinking is way above just running the streets like y'all mindsets is, or catching a case personally. Like, I do this for real. You know what I'm saying? I am on the legal teams that you will hire when you catch your case. Okay, so like, y'all gotta stop playing with me, like for real. I'm putting my foot down on that shit because these niggas be playing with me for real, for real. Don't let my content fool y'all. Okay, this extracurricular shit. Oh, yeah, they back, y'all. Oh, they not back. But yeah, y'all gonna stop playing with me. I be telling, I done told Sadie that too. Like, the y'all viewers gonna stop playing with me. Like, I'm one of the only few, other than the actual lawyers that's doing YouTube, as far as our drill culture, as far as our urban news, I am one of few that's actually doing this for real. Like, I work on legal cases for real as a paralegal. Like, I'm in school with the hopes to be a lawyer. So like, I'm actually doing this, and I'm from the urban area. So even though I may not talk street shit, because I feel like personally it's not a need for it on the internet, trust me, believe I'm not green. So like, when y'all be coming at me about this and that, what a street nigga blogger said or whatever, don't play with me. Like, I don't even have to go to that level, because half of them don't even understand what the fuck they be saying. Hence why a lot of them can watch this trial and everything go over their heads besides a nigga snitching. So stop playing with me. Like, for real. And it's funny y'all said it, because I had literally just told him that when we was having a conversation a couple weeks ago. Like, they gonna stop playing with me, because like, I do content for fun and all that, but yeah, I'm really hurt. And that's why the lawyers I do come in contact with on YouTube, ain't nobody ever said, oh yeah, she don't know what she's talking about. I know what I'm talking about. But anyway, that's that. I just had to pop my shit real quick, because sometimes I don't be popping it, and I feel like because I don't pop it, people like underestimate, like, don't play with it. Okay? Don't play with it. But I don't know what's going on. I thought we was bad. But we're not. I don't know what time is it. I gotta take a call in a minute. Yeah. So somebody had just commented on one of my videos from last night and said, yeah, but the murder car was across the street from his house. He gave him money for the car cover. I feel like he's going down. But we also now know, okay, that Bobby Carter stays on the same street as Govan. So we don't know if the car was parked across technically from Govan's house, or was it parked across from Bobby Carter's house. You know what I'm saying? So like I said, it's going to depend on how the jury thinks, like, for sure. And we still haven't proved that he actually gave him the money. The girlfriend said she did not see or hear anything they had going on. So again, and the AutoZone receipt technically ain't the AutoZone receipt, because it don't prove it. It's like an illusion piece. That's why the lawyer was so mad yesterday. You know? That part, Jody. Hey, you said no need for a government to say anything. The state case is weak as it is. Yeah, because if he talk, then he gonna open himself to, he might go to jail for real. You know what I'm saying? But I don't think he would testify. He shouldn't. That's just how I feel about it. You know. But yeah, to each his own. Got to. Okay, so real quick before they come back in. So I still was working on finding out where is Cornelius Smith. It don't show him back in the system, y'all. I done checked by his birthday and all. It don't show him back in the system. So I still can't tell you. All I know, according to Vinelink, he was released from custody. That's all I got. The person that I said that came back later, in the system for a different part of Tennessee with the name Cornelius Smith, it's a different birthday. So I'm still working on that. Because the person that got booked yesterday in a different location, birthday was like in December or something. No. Oh, no. Smith's birthday is in December, but I think the other person that got booked somewhere else had a different birthday. It wasn't December. Hold on, I gotta check it. It wasn't December. What to do, Mickey? This Tabitha Lester. I got a new phone. Every time I make a comment, this name pop up. Okay, what's up, Tabitha? Tabitha been around for a long time. It's wild how they were communicating from June to November. Well, they were technically communicating to November. I got you. All right, we back. Now, I ain't gonna lie. I thought about the Fed thing too. I ain't gonna lie. But sometimes that happens. But I can't tell you if that's what happened. But I was thinking the same thing about the Fed stuff.
Alright. Yeah, let's go back on the record.
Court's back in session.
Bring the jury back in.
Hey, real quick. I don't even know where you came from, bus time. I don't think I ever seen you before. Like, what the fuck is you talking about? You talking about drug case stuff. I'm gonna say what I said before. At the end of the day, you got to provide more than just somebody introducing somebody to say they get the same time. They have to be more involved. You have to say, hey, bus town, this is street news. Use him to kill Dolph. Like, come on. Like, okay, like the fuck. Y'all be trying to Google shit and act like y'all know what the fuck y'all be talking about. Like, I be trying not to do that. Like, again, they have to prove more connection. How you gonna see who's right? You talking about a fucking drug case. You ain't said nothing about this case, sir. Don't get blocked because you acting real like suspect. I don't know who sent you over here, but you pissing me off because, like, what did you talking about? You talking about Reggie Wright and all that? Come on, if you want that West Coast shit, this ain't the channel for you because I don't do West Coast content. Like, for real. Like, you starting to irritate me because I don't know. You're Googling shit about drug cases and shit and then trying to tell me, oh, I'm going to be right. Like, the fuck? Shut the fuck up at this point. About to raise my blood pressure before I even get on the phone with my actual client. Shit. Yeah, I might just block you. Just go ahead. Because when you mention a West Coast case, I already knew somebody had to send you over here to fuck with me. No, they're not deliberating. The defense still got to put on a case. And then we still got to do closing argument. So deliberation ain't going, like I said, I think probably the earliest tomorrow. No, because like anybody that brings up a West Coast situation, I be knowing people be sending them over here to fuck with because everybody know I don't even do West Coast content. So he already had me pissed off when he said that. Because I know somebody sent you over here. Because why is you over here and talking about some West Coast shit? And then I'm gonna look up some fucking page about fucking Reggie Wright. The fuck? Damn. I was doing so good and I cursed you so much. But that shit pissed me off. I don't like that. Anybody that watch me know when the fuck do I cover West Coast shit?
Lieutenant Coburn, the state attorney.
Stand right here, sir. Raise your right hand facing the other.
Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, could you please tell us your full name, spell out your first and last name, please?
Michael Coburn, Michaelcoburn.
And I see the lieutenant bars in your uniform. Could you tell this jury where you work
I'm currently assigned as a supervisor to crime scene
and with what department?
with the Memphis Police Department.
And how long have you been a police officer?
Almost 28 years,
And how long have you been doing crime scene analysis, I guess?
about 15 years.
Have you been qualified as an expert in crime scene analysis in the past by the state?
I have,
And you testified as an expert?
yes,
Have you testified in Shelby County as an expert?
yes,
And crime scene analysis, meaning you look for blood, evidence in cars, houses, stuff like that?
yes,
And that's what you've been qualified on behalf by the state in many cases in the past?
yes.
Your Honor, I'll move to have Lieutenant Coburn admitted as an expert in crime scene investigation.
Ms. Williams, any objection?
No, Your
All right, qualified Lieutenant Michael Coburn as an expert in crime scene analysis.
Yes, sir. Yes, Your Honor. Back in 2021, I think you were a sergeant based on your reports, is that correct?
I was assigned to homicide.
And were you doing crime scene with homicide back in 2021?
I was,
Did you happen to work on the crime scene analysis for the murder case of Adolph Thornton?
for vehicles, yes,
Okay. And did you specifically process a Mercedes-Benz vehicle in that case?
I did,
And was that car recovered, and I guess you looked at it on November 20th of 2021, is that correct?
yes.
Okay. I'm going to show you a few photos that have previously been marked into evidence and just make sure that's the same car, okay?
Okay.
My other lawyer, Robert, will do that. We're going to put in Exhibit 11 that's previously been marked and entered. I know it's a little bit of a distance shot. Does that look like a Mercedes that you processed?
Yes.
Next, please. Exhibit 12, it'll be 12, 13, and 14. I just want to get the jury acclimated to the car. Close-up view of the car.
Yes, sir.
Same license plate, everything that you processed.
It is.
Okay.
13.
Yes. I've said we're going to do 13 and 14. Just the front view of the same car?
Yes, sir.
Okay. Same thing?
Yes.
And then where do you process the car?
At 475 Clank, it's a warehouse.
Okay. So I guess it gets towed over to the police warehouse?
Yes, sir.
All right. With regards to processing the car, can you tell the jury what exactly you do?
Primarily, we document evidence, collect evidence. When we process it, we usually process for prints, touch DNA, and just evidence like clothing or something, anything that investigators looking for.
You also look for blood.
Yes,
You also look for evidence of somebody trying to clean up the crime scene.
sure.
So with regards to this Mercedes, I think they used to call it luminol, and that's what you hear on TV, but it's Blue Star now, right? That's what you guys use to look for trace evidence?
Never use Blue Star because luminol requires more darkness than Blue Star does.
All right. And Blue Star was used in this case?
It was.
All right. So without getting into the nuts and bolts, you process this car with Blue Star?
Correct.
And if I were to tell you that a witness has said that he took a towel, put a bunch of bleach on it and wiped the car down, is there any evidence of that in this case?
No.
And you would see that with the luminol, that there's bleach and things like that where somebody's trying to clear a crime scene.
Yes.
Okay, because otherwise people could get away with anything.
Correct.
Did not happen with regards to this car.
No.
So if I said under oath, I got bleach, put it on a towel, wipe that car down, complete lie.
Yes.
Thank you. No more questions.
Sergeant Coburn?
Lieutenant.
Lieutenant Coburn.
Yes, ma'am.
Very sorry.
That's all right.
Lieutenant Coburn, you processed the white Mercedes, is that correct?
Correct.
You found several prints outside of the car, is that correct?
I did.
You didn't find any prints on the front passenger outside of the vehicle, is that correct?
I'd have to look at the summary of it.
Just one second. Let me ask you also, did you process the inside of the vehicle?
I did.
Did you find any prints of value inside of the vehicle?
I couldn't say without looking at the narrative. No, there's a lot of print cards.
What did you say?
There's a lot of print cards that I looked at.
Oh.
That's what we put the prints on.
No further questions.
No more questions.
Thank you. Yes. Call your next witness.
Call Miss Vivian Ferguson, Your Honor. She may need some help getting up this stairs. Thank you.
Yeah, they may be done by the end of the day. That was a quick witness. But you know the defense witnesses though is to prove inconsistencies in the other witnesses for the same case. So
Do you swear or affirm to tell the truth?
So Smith said that he went back to wipe down the car. The crime scene person, nah, that's cap.
Good morning, Ms. Ferguson. Would you tell the jury your name and could you spell it for me?
My name is Vivian Banks Ferguson.
And could you spell that just because the court reporter needs to get it right?
Which one?
Your first name, middle name, and last name.
Capital V-I-V-I-A-N. B as in boy, A-N-K-S, Banks. Ferguson, capital F-E-R-G-U-S-O-N.
And Ms. Ferguson, how old are you?
80.
Okay. We're never supposed to ask that question, so I apologize. Do you live next to Cornelius Smith Sr.?
I live next to King Smith, his dad.
Okay. So his daddy's King Smith lives next door to you, right? And you have to say yes or no. I'm sorry.
Yes.
All right. And Cornelius Smith, that's somebody you know, right?
Yes.
Could you tell the jurors how you know Mr. Cornelius Smith?
He's a young man that lived next door, and the only reason I had to came in contact with him, he always would do nice things for me. Like when I go shopping, he always would get my grocery out the car and bring it in the house for me. That was good for me because I was tired. So that's not only that, that's the only time that he come around. If I needed something done, I could ask him, and he would do it. And if he charged me, I would pay him. But he never charged me for anything. To me, he was a nice kid.
So, Ms. Ferguson, you and I talked at your house last week, just a few days ago, right? You'll have to say yes or no.
Yes.
All right. And I also asked you if Cornelius Smith said a few years ago that somebody came by your house to get you $500 for him. Would that be true or false?
That would not be true.
All right. So if Mr. Cornelius Smith said under oath that, like, you're like a grandmother to him, right?
If that's what you want to say?
Okay, I'm just repeating what I've heard in court. So if he said that you got $500 for him to hold, never happened.
Never happened.
Not yesterday, not 5 years ago, not 10 years ago.
No, if somebody was going to leave something for Cornelius at my house, they probably stuck it in my mailbox or something like that. But I haven't received any cash or any envelope for him.
So if somebody said you were specifically given $500, would be a lie.
Would be a lie.
And I'm really sorry to call you. I know the last time you came to court was talking about your son's murder, so I 100% apologize. I know you were very upset at that. So thank you for your honesty.
No cross, Your Honor.
Thank you, ma'am, for coming.
Who said something about $500? I missed that. 80 years old, got that lady in name.
I don't have any more witnesses, Judge. We're going to run.
All right. Ladies and gentlemen, we have come to that juncture where you have heard all of the proof, but there's still one more piece left that you don't have, and that is the law that you're going to get from me. So give us a few minutes, and we'll get back with you. So please don't discuss this yet. Okay? Thank you.
Jurors excused.
All right.
The only thing I have to do, Judge, once we get that exhibit worked out that we were talking about, I'll move that into evidence. I didn't want to.
That's what we will, you got it?
All right, let me get the stipulation signed.
That's fine.
Make sure we're correct. Where's our? What's the next number, Your Honor?
33. Mr. Aurora,
Yes, sir.
I need you to put your client on the stand. We need to do a moment here.
Yes, sir.
This is a good time to do that. Come on around, Mr. Govan.
Yeah, actually, if it's on the record.
Is this on the record?
Yeah.
Okay.
Raise up your right hand.
Do you swear or affirm to tell the truth?
Yes, ma'am.
It's probably a little out of order, but better late than never, I guess. Mr. Aurora, would you like to ask your client some questions?
Mr. Govan, would you please spell your first and last name for the record?
HERNANDEZ
And Mr. Govan, you and I have talked about your right to testify at trial, correct?
Yes, sir.
I've advised you that I would recommend not testifying based on some of the evidentiary rulings. Is that correct?
Yes, sir.
And you've agreed with me that you do not wish to testify.
Yes, sir.
And that's freely and voluntarily. Nobody's forcing you to do that.
Nobody's forcing me.
Nobody's threatening you to do that.
No, sir.
All right. And this is something you are doing freely and voluntarily again.
Correct.
All right. I'm going to stamp this 33 on it and give you the stipulation.
Can I have that?
Oh my,
I'm just going to give the stipulation.
y'all stop it. I'm not saying, I know y'all done seen a trial before. Stop it, y'all.
So this is all of them.
This is all of them, state and federal.
Are they labeled? Yours were labeled pretty good. Did y'all, I mean, so they'll know which bite is which.
The two that overlap, Your Honor, essentially are the same. Theirs are just a few seconds longer,
Longer,
so
right.
they should be able to figure it out pretty easily.
That ain't what I.
Okay.
Are they labeled?
Ours are labeled. They will have, I believe they have initials, so like if it's an Angela Arnold clip, it will say AA, and then whatever the contents, joke or.
Right, okay. As long as they're labeled somehow, they're just not just clips with nothing
Yeah,
other than a bunch of numbers on them.
Yeah, they're labeled so I can find them, so same.
All right, this is, order stipulating to the police interview, sound bites that were testified to on yesterday, by, witness Angela Arnold.
Angela Arnold, Cornelius Smith, and also the detective. We played parts of sound bites from the interviews for all three from Your Honor.
Okay.
Yeah, Detective Browning, I'm sorry, I said Smith, it was Browning.
Okay. And the stipulation reads, that whereas there having been presented to me the Honorable Jennifer Johnson Mitchell, Judge of Division 10 of the Criminal Court of Tennessee, 30 Judicial District at Memphis for the purpose of trial, sound bites from police interviews with witnesses. The sound bites are stipulated by the Assistant District Attorney and Attorney for Defendant, Hernandez Govan, and shall be entered into the evidence by this agreement, signed by Assistant District Attorney and Attorney for Defendant. And the sound bites are captured on a black zip drive in a brown envelope that I'm going to place on here. Police sound bites, police interview sound bites.
Yes, Your Honor.
Of Angela Arnold, because this is just of Angela Arnold. Correct?
It's all of it, Your Honor. It's Angela Arnold, Cornelius Smith, and Detective Browning.
All right, police. Of Angela Arnold, Cornelius Smith, and who's the third person?
Detective Browning, Your Honor.
What's his first name?
Jesse.
All right, I put just that on the police sound bites of A. Arnold C. Smith and Detective J. Brown. We'll mark this as exhibit, collective exhibit 33. Put that back here, because I need to keep this working. Just leave it right there. All right. Have you had an opportunity to look at the jury charge? All right. Well, you need to take a few minutes, because we're gonna charge this jury, looks like after lunch. That'll give us time to, you review it, and then we'll come back and talk about it on the record, and make sure it includes everything it needs to include, and make sure it doesn't have anything in it that doesn't need to be in there. And that'll give me time to get it printed, and I'll charge them after lunch, probably about 1:30.
And just to give you a heads up, the only thing I would ask is the accessory after the fact charge. That was the only thing I didn't see in there.
Okay.
It's 3.03.
As to both.
Yes, sir.
Okay. State, any objection to that?
No.
Okay. All right, well, I'll add that. I'm gonna go back and add the other expert. I just added the Scantleberry. I'm gonna add the guy who just testified. Add the stipulation. You know, look at it, tell me what else I've left out, or just look at it. Look at it, let me know. Okay? We'll stay in recess.
What's in recess?
Water like that?
No, not for y'all.
Okay.
I need to know, probably within the next 30 minutes or so, if you think the charge is complete. I need to know what you think about the charge.
I think we're all good except for what we just mentioned.
Okay, so you have reviewed it?
Yes, we agree with us.
Oh, okay. But so, no, let's say 12 o'clock for lawyers, so we can make sure it looks like it should look. And then we'll, probably recess to 1:30, because I think lunch is coming somewhere in that time period. Okay? Understand?
All right, y'all, because I have a meeting coming up, so I'm actually about to be stepping away to do my day job. So I'm gonna have to walk away in a minute. But pretty much where we are now, the state has rested, the defense has rested. We got closing arguments coming up. The judge is gonna have to charge the jury. What does charge the jury mean, Mickey? It means give them their instructions on what they should be considering while they're deliberating. Once they do that, they send them to the room, and then we'll be here until they decide to come back with a verdict. Could it be sometime this evening? Could be. Could be tomorrow. Could be Saturday. Could be Sunday. You just don't know, okay? So, you know, we got that. Any questions? No, and then Govan will not testify in his own defense. It makes sense. Anytime you have any type of relation to anything illegal, like at the end of the day, he was a drug dealer. It's been said multiple times. He had connections to somebody that was involved in this, like, for sure. So it's like, why would you want to open that door for the prosecution to ask other questions, you know what I'm saying, about other things, to try to tie you to different things? So yeah, it makes sense not to get his tail on the stand. I know in my experience, every case I've ever worked on that has something to do criminally, the lawyer or attorney that I work for always recommended their client not to take the stand in their own defense. The only time in my experience that they really do is in like self-defense cases that don't have really nothing to do with any type of like extracurricular stuff, because I mean, who's better to say you acting in self-defense than yourself? So, but yeah, cases like this, I ain't never heard a lawyer say, yeah, get on the stand, especially if you had any type of extracurricular illegal ties to anything. Hold on, my food done. Give me a second, y'all, because I got hungry. Ooh, it's hot. All right. Ooh, shrimp fried rice for lunch. I wish. And I ain't gonna be able to eat all this. I had just did me a little microwavable dinner. One of the little healthy connections got this is zucchini, squash, chicken breast, and then some noodles in it. But and then I put some like cheese on top of it. That shit hot. So yeah. What were we? So yeah, pretty much they're gonna be out for at least the next hour. Like I said, I got like 10 minutes before I got to go. So I can either just leave it here or like what y'all want to do. Cause this call probably gonna take it's supposed to only be 30 minutes, but y'all know how that goes. I don't like to leave y'all on silence, but hey, I gotta pay bills. This shit hot. I'm so hungry. All right. So that's what I'm doing. I'm gonna try to go ahead and eat my food though before I gotta get on the phone. I'm gonna just leave it here because just in case I don't come back in time for the actual trial, come back. I don't want to have y'all watching something else. So long time, I'm probably gonna leave theirs up. So I'll be back, and of course, you know what I'm saying. Hey, those that wait out for me, I'll just keep the conversation going in the chat. But I will be back.
Mr. Aurora, I don't remember. Tell me what it was that you said needed to be added or removed. I think I did it already.
Accessory after the fact.
Oh, right. So I'm adding,
Yes, sir.
the state didn't have an issue with that. I think you asked for that too. Okay. State also asked that I include solicitation to both the conspiracy and the murder.
Okay.
So I am adding those.
Do we need all the lesser included if I just want to go in the indictment, or is that just something?
Well, it's,
I can't go all or nothing?
no,
Okay.
can't do all or nothing. Court of Appeals might not like that if they have to review it.
Even if I waive it?
Yeah, because the state, we wouldn't do so. I mean, if y'all agree,
Yeah.
if you agreed, I think I might be able to get away with it, but
Okay.
somebody's gonna be unhappy with that. One party or the other is gonna be unhappy, and be like, that's bad for those legends included, so. So I'm adding solicitation to both the conspiracy and first degree murder, and I'm adding, accessory after fact to both also. On page 5, in the definition of conspiracy to commit first degree murder, in paragraph 2, the second part to that was actually the definition of first degree murder. I'm scratching that. That kind of confuses things. So paragraph 2 will read that each of the parties to the conspiracy had the intent to commit the offense of first degree murder. Okay. I did add the stipulations. I added the experts. I took out defendant testifying. So let's go back to, I guess, for it to be complete. On page 4, where I list the charges. Of course, I'm gonna add solicitation and accessory after the fact there. And when it comes to count 2, I've added solicitation to first degree murder, second degree murder, aggravated assault. Do I need to put it on the assault? Just out of an abundance of caution, or y'all good if I don't? It just kind of feels like overkill for me to get that done.
I don't think.
Okay, so the parties agree, I will leave it off of assault. Assault is the last offense there. Okay. Anything else?
Yes, sure. We skip my mind about the mere presence instruction.
Who?
Mere presence instruction.
As to the conspiracy,
As to the conspiracy.
it's in a definition somewhere. Where did I read it?
Thank you.
Hold on, let me. It's part of a definition. I think it's probably in the conspiracy definition.
Okay, if it's there, that's fine.
Hold on, let me.
Page 18. Page 18, Judge.
Page 18. In what? Because now I've added a bunch of stuff. What is it a part of?
So it's under the criminal responsibility for conduct of another section, right above accomplice.
Okay. Yeah, last paragraph of the second to the last paragraph. However, mere presence during the commission of offense is not sufficient to support a conviction. Is that? All right. Just a hard copy. All right.
And then between closings, we'll need a second to switch to
That's fine.
download.
That's fine. That's fine. Do I need to put a time limit on closing arguments? I normally don't. But I just see everybody to be reasonable.
Yeah, I'm hoping it's not that long.
You've been pretty fairly reasonable throughout. I haven't had to clear my throat or look at you hard, so.
That's what I was keeping back to you.
Right. I think I know of ways to get your attention, and I don't want to have to do that.
I don't want to go long.
And I'm gonna give you the opportunity to present your case. I'm not getting ready to step on that. Just when I start hearing the same things over and over again, I get restless, and that's just.
If I'm doing that, then I've really screwed it up.
Right. Okay. Well, good. So, let's stand in recess till 1:30.
Was in recess to 1:30.
All right, thank you.
Thank you, Truth Team, for holding it down. I'm finally off the call. I'm about to grab me something to drink, and then I'll be right back because I got to play it back to see what new charges y'all said came. So give me 1 second.
Mr. Aurora, I don't remember. Tell me what it was that you said needed to be added or removed. I think I did it already.
Accessory after the fact.
Oh, right. So I'm adding,
Yes, sir.
the state didn't have an issue with that. I think you asked for that too. Okay. The state also asked that I include solicitation to both the conspiracy and the murder.
Okay.
So I am adding those.
Do we need all the lesser included if I just want to go in the indictment, or is that just something?
Well, it's,
I can't go all or nothing?
no,
Okay.
can't do all or nothing. Court of Appeals might not like that if they have to review it.
Even if I waive it?
Yeah, because the state, we wouldn't do so. I mean, if y'all agree,
Yeah.
if you agreed, I think I might be able to get away with it, but somebody's gonna be unhappy with that. One party or the other is gonna be unhappy, and be like, that's too bad for those legends included, so. So I'm adding solicitation to both the conspiracy and first degree murder, and I'm adding, accessory after fact to both also. On page 5, in the definition of conspiracy to commit first degree murder, in paragraph 2, that the second part to that was actually the definition of first degree murder. I'm scratching that. That kind of confuses things. So paragraph 2 will read that each of the parties to the conspiracy had the intent to commit the offense of first degree murder. Okay. I did add the stipulations, I added the experts, I took out defendant testifying. So let's go back to, I guess for it to be complete. On page 4, where I list the charges. Of course, I'm gonna add solicitation and accessory after the fact there. And when it comes to count 2, I've added solicitation to first-degree murder, second-degree murder, aggravated assault. Do I need to plead on the assault? Just out of an abundance of caution, or y'all good if I don't? It just kind of feels like overkill for me to get that done.
I don't think it.
Okay, so the parties agree, I will leave it off of assault. Assault is the last offense there. Okay.
All right, y'all. So these are not added charges. These are lesser charges. And to be honest, if I was on that jury, I would probably definitely vote guilty on the lesser charges. And I'll explain to y'all why. I personally don't feel like they proved that it was conspiracy to commit murder or murder. However, I do think they proved accessory after the fact, being that they have provided evidence that, yes, indeed, Govan introduced Cornelius Smith to Juke, and that he went to see Govan after the murder, even though it could be alluded that he went to buy pills. It's just too much of a coincidence that happened. So I probably would definitely say accessory after the fact, and under the presumption that the witness was telling the truth, the girlfriend, when she said they actually did go to AutoZone and buy the chair cover, as Smith said, I would definitely vote guilty on accessory after the fact. Solicitation to murder, I know they're going to break it down when they do it to the jury, but give me 1 second, because I kind of feel like I will vote for solicitation to murder also. Let me make sure I understand what that means in Tennessee, though. Give me 1 second. What is going on with my computer today? A person commits criminal solicitation with the intent that offense be committed. A person requests, commands, or attempts to induce another person to engage in conduct that would constitute the offense or attempt to commit. Solicitation to commit murder, it means a person intentionally tried to get someone else to kill another person. One level lower than one. So solicitation to commit first-degree murder is a Class B felony instead of a Class A felony. Prison term can be 8 to 30 years. Let me think about that one. No, they haven't came back. They'll be back at 2:30 p.m. Eastern time. Solicitation for murder. I for sure will vote guilty on accessory after the fact and not murder. But solicitation, I'm trying to think. Have they proved that? I think the throw off with that is that I think the jury might bite on the solicitation for murder, because the fact that Cornelius Smith said that he was introduced to Juke on the notion that he had did the shooting of paper route rule. So that means he's being introduced as a quote unquote shooter to Juke, and that it was discussed about the jury might go for that. So if I'm being honest, I feel like the jury probably will convict him on the lesser charges. I just don't see them actually convicting him on conspiracy to commit murder and murder in the first degree. I just don't see that. However, accessory after the fact and solicitation for murder, I can see that. I think the state proved their case on that. What was added? So nothing technically was added, but lesser charges for the jury to choose. So instead of murder in the first degree, they're gonna have an option to choose accessory after the fact. Instead of conspiracy to commit murder, they're gonna have the option to do solicitation for murder. Now, yeah, I'm eating candy, my bad. What may sway a little bit is the fact that Cornelius Smith said he was going to Govan's house that day for drugs. So a jury may be like, well, it really was a solicitation. He was just there to buy drugs, and just so happened, hey, I saw him on the shooting. But that's if anybody thinks like that. I think the lesser charges might go down. I ain't gonna lie. I think definitely accessory after the fact. Damn, these candy, y'all, I ain't ate candy so long. It tastes so good. I can go for that accessory after the fact, though. I ain't gonna lie. I think the state proved that. The girlfriend sealed the deal with accessory after the fact. It makes just too much sense. You introduce him to Juke. He call you. Yeah, I can do the accessory after the fact. I'm kind of on the line about the solicitation. But if I had to choose between the conspiracy and solicitation based off the evidence, I would go with solicitation. So, yeah, your lesser charges makes more sense. What y'all think? I know I'm smacking in y'all ear, my bad. Let me mute talking to this camera. Okay, I'm done smacking. Okay, Mo says she agree. Yeah, I think the lesser charges gonna fly for sure. I will be shocked. I'm gonna tell y'all straight up. I will be shocked if the jury comes back and say guilty on original charges. I ain't gonna lie. I will be shocked. My mouth will drop. Okay. Jury can't prove solicitation. The introduction doesn't mean they conspired to commit murder unless witness claims that and has proof otherwise hearsay. Go for lesser charge of after the fact. The only reason why I say the solicitation may fly is the fact of how the introduction, according to Cornelius Smith, the introduction to Juke was, hey, this is Lil C. I sent him on a hit before on the paper route rule. He definitely will put in that work. So that's why I say I believe. And then he said, this is who I was talking about. So now we go off of what Cornelius Smith said. That I say the solicitation just makes sense to me, because based off what Cornelius Smith said, the conversation was like Juke and Govan had a conversation about him during the Paper Route Woo shooting. Then he introduced him and made him remember, like, hey, this is what I was telling you that I sent on the paper. So, like I said, I feel like that was stick, to be honest. That's just me though. Based off that. And then he said don't, and then the fact that the state tied everybody to that meeting on July 27, 2021. I think once you take the definition, and the judge is going to go over it herself, but once you take the definition of solicitation in Tennessee, it makes sense. I don't think the conspiracy is there because it's too many pieces that came in that didn't include or didn't prove that Govan was actually involved with the actual plot on Dolph. Because again, the witness already said he was a junkie. He got the spills from Govan. So that's just my thought process. And it wouldn't be accessory after the fact for the conspiracy charge, though. Because if anything, it would be before the fact. Because he was the introduced. So the accessory after the fact ain't gonna fly with the conspiracy charge. KG said, yeah, the lessons made way more sense than the original charge. Yeah. And like I said, the evidence is there for those. It's just gonna be a matter of how the jury looks at it. Now, I would have to hear. Oh, let's finish this. I think they were still talking. I had paused it. So hold on.
Yes, Your Honor. We skip my mic about a mere presence instruction.
Who?
Mere presence instruction.
As to the conspiracy,
As to the conspiracy.
it's in a definition somewhere. Where did I read it?
Thank you.
Hold on, let me. It's part of a definition. I think it's probably in the conspiracy definition.
Okay, if it's there, that's fine.
Hold on, let me.
Page 18. Page 18. Judge.
Page 18. In what? Because now I've added a bunch of stuff. What is it a part of?
So it's under the criminal responsibility for conduct of another section, right above accomplice.
Okay. Yeah, last paragraph of the second to the last paragraph. However, mere presence during the commission of offense is not sufficient to support a conviction. Is that? All right.
All right, so that was it. Okay, can he or jury prove that combo happened, or is a witness trusted to the degree of persecution of Govan? Hearsay has lost many trials and cases. Well, it wouldn't be hearsay because Cornelius Smith was actually there, so that's not hearsay. So the way the jury, in my opinion, can prove or can assume that the meeting happened is the fact that the defense did not challenge that meeting didn't take place. The defense did not challenge Cornelius Smith when he said he went to buy pills from Govan, and when he got there, Juke was there, and the conversation continued. So the fact that they did not intercept to say anything about that, then you can take that for what it is, you know. But the fact that Cornelius Smith was one part of the conversation, two physically there, it wouldn't be hearsay. Now it'll be a matter of if you take that into accountability if you're on the jury. Because don't get it twisted, I don't believe everything Cornelius Smith said, but I'm real big on when the defense doesn't challenge something that a witness says. So the fact that they did not challenge the actual introduction scenario, although I don't think of the actual conversation was in play, I do think the encounter happened based off that they didn't challenge that. So, oh, no challenge yet? Then it's fact, still proven otherwise. Right, yeah, they didn't challenge that. And anybody that was watching that, if I'm wrong, let me know. But yeah, they didn't challenge that. That stood out to me, and I wrote it in my notes that they didn't challenge the meeting. Now, me, I just didn't believe the actual breakdown of the conversation, but they never challenged the meeting at all. They never brought anything, and none of their witnesses came to say anything about that meeting not happening. So, so that's why I said I feel like the solicitation definitely will fly based off that. And another reason why I think the solicitation is going to go is because they also didn't challenge the fact that Govan put Smith on the paper route Wu shooting. That's another thing the defense didn't challenge. So the fact that Cornelius Smith is saying he was introduced to Juke as the shooter in a paper route Wu shooting to Juke, and then they continue to talk about hits and payment, it's kind of hard to not just look at the obvious that he was introduced to Juke to be a shooter, if that makes sense. That's the way I'm looking at it. So, like I said, the conspiracy, I feel like, was a reach in this situation when you had so many hands in the conspiracy. Although some people are deceased, they, because I think TZ was killed in 2023. Juke was killed in 2024. We don't see Bobby Carter on here. It's just too many other players involved that the conspiracy just broke down. So ultimately, I do think Govan definitely introduced Smith to Juke, but I feel like Juke was definitely the mastermind on the Dolph hit. Now, not saying they wasn't all working and play together. I just don't think in court they proved it. Because, Smith was saying, nothing wouldn't have happened without Govan. And I think the only thing you can say that wouldn't happen, maybe Smith would have never been introduced to Juke in that team. But I feel like straight drop, all that, they were all working for Juke, not Govan. Hence the reason why Jesse Brown, the detective, said on the stand that, yes, in the communications between Juke and Straight Drop, that the night before the shooting, they talked for 6 minutes and a turkey emoji was sent. Hence why Straight Drop was one that provided Cornelius Smith the gun, unlike in the paper route Wu situation where Govan directly sent it. So I feel like just based off of what they provided and how the paper route Wu shooting took place and how the Dolph shooting took place, if Govan was in charge of this hit, he would have been more hands-on to provide Smith what he needed. I feel like this was not that. Govan sent Smith over there to the CMG hitters, okay? And boom, here we are. Nikki said this bigger than us. Okay, it's definitely that, okay? Definitely that. But yeah, that's where my thought process is. All right, in about 8 minutes, hopefully they come back and we can start closing arguments. Y'all already know at 3:15 to 3:45. I have to get my granddaughter and get her situated with lunch and all that. So I won't be available. Hopefully they be in closing arguments though, and I'll be listening as I'm moving around. From there, I'll be back on to chop it up with y'all. I have to leave about 5:15 p.m. Eastern time because I have to go to my grandbaby's open house. So just know, as long as they deliberate, we will be in the mix. So we'll be live tomorrow, unless for some reason they come back today. Okay. Cook said I think he may get accessory, but I won't be shocked if they say not guilty on all charges. All right. Don't worry, Govan going to life unless he gives a TTI. There's too many other M's and shootings after Mr. Dolph with no one in custody. Yeah, Cornelius taking everybody with him. Watch, they ain't pay him. I mean, I don't think Cornelius had that much details and insight to too much of anything other than this case. I could be wrong. It's just I don't think he had anything else. At this point, if he didn't already negotiate a plea to get out, to give up information, I doubt that's going to happen. At the end of the day, he's sick. Hell, who knows what he's sick with, how long he lived, you know what I'm saying? He's already out on bond, you know, I don't know. The recipe for him turning state just seemed a little far to none at this point because he would have already did it, if you ask me. But we'll see. Time will tell. That's about it. I seen the camera move. I thought it was about to come on, but they should be on about 6 minutes. Yeah, my grandbaby like eggs so much. She be wanting me to make her eggs when she get out of school. But her bus don't never be on time, so I don't be wanting to make her eggs too early and they be cold. I might make her eggs at like 3:10, because normally they get here about 3:20. About 3:10, I might just make her eggs. And then I'll be mad if she don't want eggs today. She be so flip-flopping. I need a nap. I done had a long couple of days. When I'm doing lives and working in the same day, it just be so much. But I appreciate y'all for pulling up, hanging out with me. How you cook her eggs? She just like scrambled. You know, she don't like no cheese on it. Yeah, she just like scrambled. So I'll probably make her scrambled eggs and put her some nuggets in the oven. She like them dino nuggets. And make her some dino nuggets. Cause sometimes, especially if I gotta take her home, I'll take her by McDonald's. But since today I don't have to take her home, and then we going to open house, I'm just gonna make her something at the house. Cause if I ain't gotta go out there in that heat, I ain't going out there, okay? So yeah, I think that's what I'm doing. And then she be so thirsty when she get home. Like when she get off that bus, I don't know what they don't be giving my baby to drink at school. But the first thing she wants is juice. I already put her one of her Welch's juice in the freezer so it can get real cold. But she be thirsty as ever, thirsty and hungry. Her mama feel like they don't be feeding her at school. But I'm like, even when my daughter was young, she would eat, but sometimes she ain't like what was there, and she'll still be hungry when she get home. So, you know. But, you know, this is my daughter's first baby and first time going to school, so she just think don't people be trying to take her baby out, okay? But yeah. Say, dang, you a whole grandma out here. Could have fooled me. Yes, okay. Yeah. And she be running me quite crazy. She be missing my grandma. So, like, from the time she was, like, 4 months till a couple weeks ago, my grandma, my dad's mom, was her child care provider. So they going through separation anxiety right now. Because, like, when she get here, she be ready for me to take her to my grandma. Okay. They just probably giving them 4 ounces of juice during lunch. They got to, because she be thirsty. Okay. thirsty. And my daughter be packing her a snack bag. But when she get home, a lot of her snacks still be in her little lunch bag. So I don't think she really be getting a chance to eat that like that. And I told her it's probably a time thing. Like they may not have time. And you know, she's in pre-K, so like the parents get assigned a day to bring snacks. So I'm like, if I was a teacher and we only got X amount of time, I'm just gonna pass everybody a bag of chips if that's what's on the menu for the day, instead of letting people go get their lunch bags and all that. So that might be it. So I try my best to, when she about to get home from school, just go ahead and have her stuff ready so she can go to the table and eat, or have it where she can put it in the car. Cause like I said, when I take her home after school or down to my grandma's house, because like on Thursdays and Fridays, no, Thursdays, because technically Friday's not really, but Thursday I take her to my grandma. Don't eat all the snack and drinking the juice up either. To be honest, so she has her own juice and I have mine, because I'm a thirsty person too. And since I had bariatric surgery, I can't really eat snacks like that. So we don't have no problem with that. So I have my own like protein snacks and stuff, and then she have her own. But we definitely can't share no juice, because we for sure wouldn't have no juice, okay? But yeah, she do the juicy juice. I got her like a juicy juice, little like juice boxes or whatever they call it, the straws. Y'all know what I'm talking about? And I get me the Welch's juices, but sometimes she drank my juices. But for the most part, I try to do them separately, because child, listen. But no, I don't touch her stuff every month. And even like when she was in before school, like during the summer, I would watch her like 2 days a week or whatever, the days I'm working from home. And she got to have her own snacks. But that child be trying to eat all my stuff. I'm like, girl, you ain't about to eat no protein brownie. She be swearing up and down she about to eat a protein brownie. Like, girl, you ain't about to eat no protein brownie. But yeah, she like fruits a lot. So I try to get her like keep fruits in the house. I like fruit, but we don't like the same fruits. Like she can eat strawberries all day, every day. I like strawberries, but not like to eat them all day. I'm more of a grape person. I'll eat grapes. Give me like 3-4 grapes throughout, you know, every now and then throughout the day. I'll be cool. Oh, is your grandbaby gonna be a Libra? Please be a Libra. You know I'm a Libra. Shout out to my Libras, okay? And I'm an October Libra. My alarm going off now. Look, I'm gonna tell you, you gonna love being a grandparent so much better than being a parent for so many reasons. Like my grandbaby is my ace boon coon. My daddy be like, she act just like I did when I was a little kid. Like she be stressing me out, okay? But I love having a grandbaby. You can spoil them and send them home, okay? Send them home. But I'm very hands-on. I like, and see what, when you're a parent, you know what I'm saying? You're like, you have no choice but to do for your kids, right? Because you are, okay, I see the Libras in the building. So you are the provider. But when you're a grandparent, it's like by choice. So like I buy her so much stuff because I choose to. It's not like I have to, but like I do my own thing. Like when back to school, my daughter is definitely the GOAT. Okay. So she definitely do her big one. Okay. But if I'm in a store and I see like some stuff I like, I'm just gonna pick it up and be like, hey, come pick this up for the baby. You know, it's just like less stressful, but it's like you love them so much. Now, if my daughter start having more kids, I don't know if I'm like the other ones. The first one is just that's my girl there. So I don't know. We have to see when that time comes, when she start having more kids, how I rock with them. But this been my ace boon coon since she came here, okay? And she got Mr. Truth wrapped around her fingers. Her little car broke down. Now, when my real car break down, I call Mr. Truth, he be dragging his feet. her toy car break down, and she called grandpa. Grandpa about to pull up and find out why her car ain't moving. Like, she really got him wrapped around. And she's my grandma's first and only for now great grandchild. So my grandma made clear she's the favorite. We know that. Like, you ain't even had to tell us. Okay, we know she's your favorite. But yeah, they be having separation anxiety. We was in a car the other day after school, rolled past. She know, like, she's so smart. So she recognized the car dealership by my grandma's house. And she was like, I want to go see Nana. So we go to my grandma's house. I'm thinking we just stopping by. So I'm like, come on. She was like, no, I'm staying. See you tomorrow. I'm like, what? Not you to use me to drop you off. So that's why we start saying Thursdays is I'll take her down there because, yes. She was like, no, I'm staying. I started buying stuff for the baby the same week she told me she was expecting. I wish, for those that's new to my channel, my grandbaby was a surprise. So we didn't know she was coming until she was coming, literally. Okay. So it was a surprise. So I went all out at that point, but she was already here. But I wish I could have led up to just, because we had the baby shower with the baby there. Like, that's how just out the blue it was. That's me, Mickey. My daughter has 3 children. My first grandchild is my 8th. Okay. Is it Callie? Callie? Is that how you pronounce it, Callie? Or is it Kayla? How do you pronounce it? Cute. I like the spelling, though. I like a unique spelling. Like, I like that. But yes, y'all. Shout out to the grandparents. But let me tell you this, though, now. Don't get it twisted. I love my grandbaby. But I am not that grandparent that babysit all the time. No. I got a life too, Jody. Okay? I'm still young. Like I said, I'm not even 40 yet. I'm still young. And even if I ain't got nothing to do, even if I want to sleep all day, that's my business. That's your baby. I am not one of them. Okay? I am not one of them. Because I feel like once I say, yes, I'm going to keep your baby, if something pop off, I can't even go nowhere. Because I'm stuck here with your baby. No. Okay? I am the type of grandparent, you got to book me in advance. Now, I ain't talking about like financially, because I do not charge to keep my grandbaby. But when I say book me, meaning you got to get on my schedule in advance. Okay? Look, you got to get on my schedule, baby. Because no. Listen, and on a weekend, girl, shoot, I don't know what the wind may blow. And I have one biological daughter, and then I have a stepdaughter. So technically, we have 2 kids, me and Mr. Truth, and they both grown, living their own life. So, and we separated a couple years ago, but we finally decided to try to see what this do. We done been married 15 years at this point. And we don't got time. We be in the streets, okay? We be in the streets. And sometimes we be asleep. But nevertheless, we ain't babysitting no baby. Now, certain situations, like, if she got to work, for sure. You know what I'm saying? Because my schedule is more open with my job. Like, if I wake up in the morning and decide I want to just work from home, I can do that. Unless it's a day I have court or something scheduled. You know what I'm saying? That's different. But I have more leniency. So my daughter works for a law firm also, but she ain't on the level. Like, she got to go in the office. So I'll definitely, no questions asked, watch the baby without no hesitation. But for you to go to happy hour, girl, better find the drive-thru. Look, it's a good thing. I like being a grandparent. I wish my grandbaby called me grandma, but she don't call me grandma. She called me nanny. So I'm nanny. I wanted to be grandma so bad. Everybody was like, you want to be called grandma? Hell yeah, I want to be called grandma. But I'm nanny, and then Mr. Truth is Papa. So he get his name he wanted, but I can't get what I wanted. So, listen. So, Yep. So welcome to grandparenthood. Is lit over here. But yeah, like no grandparents that be like, oh, I just don't got nothing to do. I watch the grandkids all the time. Well, that's you, not me. Cause I tell you, I don't even care. All I'm doing that day, okay, is rubbing my feet together. Listen, I ain't watching no baby. You sound like you spoiled. They say I'm spoiled. They say that. I'm the only child too, though, so I do kind of got that only child syndrome. But I don't really think I'm spoiled. But other people say I am. So I guess it's up in the air. Like if I call my best friend right now, she gonna sound spoiled. But she's spoiled. You know what I'm saying? So it's up in the air. It's up in the air. My daughter is definitely spoiled to the fact that she come her y'all and I be cussing her out. Okay, her. And I'm definitely agreeing to baby for sure. I love my grandma, my paternal grandma. Love her, love her, love her. And see, I had her when she was in her younger years because I think when I was a little kid, my grandma was like in her 30s or something like that. Something like that. And so I used to get my ass cut, okay? Cut. Like, that's back when grandma like had like one of those like quick reflexes. But then, you know, I saw her with my daughter. It was a little more lenient. But my grandbaby, man, she run amok over my grandma now. Okay? I be like, grandma, whoop her ass like you used to whoop me. And I'm talking junk, I don't even cut her butt. So I'm one of them yelling grandmas. And don't be doing nothing. Okay? But blowing out steam. Blowing out steam. That's all I be doing. I used to talk so much junk in the beginning because my daughter was like, I want to do gentle parenting and all that. And I'm like, what? Like, girl, I ain't gentle nothing over here. And child, my grandma got me wrapped around her fingers, okay? I grew up as the only child. I don't even want to be around. I grew up as the only child. I ain't that bad. I ain't gonna lie. I'm a little selfish, but not like that. And the reason why I was a teen mom, so even though I was the only child, technically I had my daughter when I was 14. So we grew up to a certain degree together. You know what I'm saying? So I ain't really selfish, but I do like to be in charge though. I don't know if that's an only child thing or the Libra in me. I don't know. I do like being in charge though. I do want to be the boss for sure. I do want to be the boss. Don't tell Mr. Truth or nobody I said that, y'all. Because he'll be like, I've been telling you that for almost 20 years. You always want to be the boss. But they allow me to be the boss too. Like even with my friends. They love saying that too. But every time we plan something, they want me to plan it. So I like to be in charge. I will say that's a double-edged sword, though. Now, it's 2:40. They supposed to be back by now. But anyway, we having a great conversation. That's what all women do. But yeah. I was just so happy. Listen. Wow, Mick, I had my daughter at 14. She will be 41 September 19. Hey, listen. That's why I remember when I first started YouTube. And, you know, I was open about it because, I mean, I ain't ashamed of it happening. It's part of life. It's part of my testimony. It's part of my journey. But when people be like, young parents don't take care of their kids, I'm like, you got to be fucked up. I raised mine. My grandma didn't raise my daughter. My mama ain't raised my daughter. No family. Like, I raised my daughter. You know what I'm saying? I made a lot of sacrifices based off my choices to have a baby so young. And I raised her. Okay? So, yeah. And she turned out great. A little rough around the edges in certain situations. But she turned out just fine. Okay? Just fine. I know people that had kids way later in life that turned out off the chain. I just hate when that stigma be put out about teen parents. Like you can't raise, you know, a successful child just because you had them young, you know? Now, trust me, believe if I waited, yeah, we probably would have definitely some more stability early on. But I mean, the lessons I had to learn then, I will say this, I'm thankful, okay, that a lot of my learning lessons, my baby was young, so she don't even remember it. Like, you know what I'm saying? She don't remember the struggle. And that's why I like, because I remember the struggle as a kid. I remember the struggle. But my daughter don't remember the struggle, okay? My daughter didn't have to go through the same. She had struggles, but not the same I had. Like, she ain't never went to sleep hungry, okay? I done went to sleep hungry. You know, she ain't never had to deal with lights getting cut off. I had to deal with that, though. You know what I'm saying? So it's certain things, even though she still had to deal with things because we was figuring it out, she didn't have to deal with all the things that I have like nightmares about, you know, as far as the stuff I experienced. So, you know, I say, hey, I successfully did that, okay? Because she'll tell me, because like, you know, by the time she got to school, they wasn't teaching cursive, they wasn't teaching nothing. And I used to teach that at home, okay? And she used to be so mad, but now she understands. Cause she's like, I remember when she was in high school, she was like, Mom, I went to the store with my friend, and she didn't even know how to fill out a debit card receipt. She was like, oh, my mama taught me how to do that. That's why I be like, you can't blame the schools. If you want your children to know something that maybe not is being offered in school, you got to teach them yourself. Hey, we had this wooden brown table that I had got when I first got my first place from the thrift store. And to this day, we still got that table. Actually, Mr. Truth got it, but we still got that table. I'm talking about a wooden old table, like the sturdy round top tables. Listen, okay. I used to sit her at that table, taught her how to write a check. Now, listen, we talking about 16, 17. People wasn't really writing checks, but she know how to write a check. Yeah, you got to teach them. You can't be mad or be in an uproar because school don't teach. You got to teach them. And my whole thing was I wanted her to know the basics. You know what I'm saying? Like, I wanted her to know things I wish I knew. Like, we talked about credit. Nobody talked to me about credit when I was coming up, you know, at all. Talked about, like, I even have, when I bought her first car, her junior year of school, hey, she had a job. She started working at 15. Okay, you gonna pay something on this car, but we gonna put your money in an account so that when you graduate, you got something to start off with. But I'm telling you it's for your car. But in the back of my mind, putting in an account so she can have something. They wasn't doing that when I was younger. I didn't have that luxury. You know what I'm saying? So, like, that's it. Like, it's gonna be struggles everybody go through, but yeah. I just knew if you want to be a rapper, you wasn't about to say you had to eat freaking water sandwiches, okay? Okay, like, for real. And I always been honest with my daughter too, so she knew I was young when I had her. And although when we found out, because she hadn't graduated, what's so crazy, her senior year she was pregnant and we didn't even know. So like 2 months after graduation, she had my grandbaby. I told her how hard it is to raise a kid. But hey, it happened. It's here, you know, it's done. You got to deal with it. I ain't loosen up, though. I'm like, no, that's your baby. You got to deal with that. That's your baby. I told you, okay, it's hard out here with a baby, especially young. You know what I'm saying? You trying to go to college. You trying to do that. All that. Mm-mm. And why she was supposed to go to Clemson University, y'all. And that's a good school. She was supposed to go to Clemson University. A month before she would have left to go to Clemson, she had my own grandbaby. And I remember her baby daddy mama saying, oh, y'all gonna go off to school and, you know, between me and your mama, we gonna take care of the baby. I said, the fuck we ain't. No, we're not. They're gonna take care of their baby. They have to just, no, because that's not how the world works. No. We're going to be there to support, but no. So while she was in a hospital bed healing up from having her baby, she had to withdraw from Clemson. And because they couldn't accommodate the fact that she just had a baby, she found her a school that allowed her to continue to go to school, but do it online. That's how we do it, okay? You have to be able to adjust to life ups and downs. But I look at that lady like, lady, what the fuck you talking about? I ain't raising no more kids. What is you talking about? Talking about me and your mama. What the hell? And I told my daughter, so you gotta watch her, because she wants your baby. Because if that's a first solution you come up with is that we gonna take care of the baby, you crazy. Okay, you is crazy. So I'm just talking until this come back on. But y'all know in a few minutes I'm gonna have to step away to get prepared for my grandbaby. But yeah, y'all like, stop making it too easy for your kids. Look, I'm an OG in this parenting thing now. That's why I say I'm an OG, because mine's grown. Okay, I made it. Okay, I made it. I was so happy. Okay, when that child moved out on her own, I was so happy. The same day they moved out, I had to redid that whole room they had. I was happy. One day, my daughter called me and she was pissed off about her job. And she said, I'm about to just move back home. I said, where your home at? Can't move back here. Now, mind you, at the end of the day, all BS aside, okay? If my daughter ever needed to come home, she's more than welcome to come home. But what I'm not about to do is reward poor decisions. No, you better suck it up. Go get you a slushie. Calm your nerves. Go back to work so you can pay your bills at your own house. Not about to say, oh, yeah. And you know why I say that? Because I wish somebody did that to me. I had to got so comfortable saying I can go back home to my grandma. I can go back home. Till I ain't get myself right till I was like 21. Okay? 22. So, you sound like my grandma Mickey. I had to, okay, for real. Ain't nobody got time for that. I know how, man. Listen, all the parents out there, you ever barely was making it, but you was making it. Then all of a sudden, your child or your children outgrow their shoes. They could fit them yesterday. Now today, they feet hurt. And you gotta make something shake, man. I still got PTSD from stuff like that. No, I don't want to raise no more kids. That's why I ain't have no more. Me and Mr. Truth wanted kids. And I'm gonna tell y'all the crazy part. When we first got married, we wanted more kids, but we couldn't afford no kids. On some real stuff, we could not afford no kids, but we wanted them. But once we got financially stable and like together, we ain't want no kids. We ain't want no kids. Yes, Kiki. I got to clap for that. I got to tell my daughter that somebody said the same thing I said. I used to tell her that all the time. I'm teaching you to live without me. I used to say that to her all the time. Because when you got younger kids, all you think about is, what if you don't make it to this point in life? What if you don't make it to this stage in life? So I got to prepare you so that I can be at peace and at rest, that you are able to handle yourself. So yes. I used to tell my daughter that all the time. And she's be like, Mom, I be like, no, I'm serious. See, a lot of parents teach their kids to need them, but you got to take the titty away at some point and let them be able to stand on their own and be productive adults. For sure. And whatever light they're going to be in. Because I remember my daughter wanted to go to college. She wanted to be a lawyer. So that wasn't something I pushed on her. She actually inspired me to want to get back into it, you know? So I'm glad she's with a black law firm and they have been good to her. They've been good to me, motivating me, to put my hat back in the game. So things worked out. Let's be real. Most people can't afford kids. We just make something shake the best we can. Facts, Angie. And that's why I ain't trying to make nothing shake. Okay? I love only feeding myself. Like, I love the fact I can be down to $20. It's my whole $20. I ain't got to try to feed 4 people with $20. I ain't got to try to feed no kids with this $20. $20 just for me. Okay, it's all mine. Mine. I salute you, Mickey True. I believe you did a wonderful job with your daughter, even though you started early. I appreciate it. Thank you. She took the LSATs a couple months ago. She'll be starting law school. I don't know if it's this fall or the beginning. No, I think it's next year. Next fall. She'll start law school next fall. Yeah, so I wanted her to be a doctor, to be real, but nah, she's a lawyer, and she's going to be a criminal lawyer. And boy, that's going to be a feisty lawyer, okay? Boy, if y'all ever, I'm going to tell her we got to do a debate one day. Boy, we be going, you think, when I be talking y'all on a debate, man, y'all got to hear me and my daughter go back and forth. Okay? And my daughter is definitely pro-black. Right? She's definitely like pro-black for sure. Okay? Pro all that. So if that tells you, she be mad at me sometimes. Cause she was like, Mom, you need to find you I think my dentist is he's not white, but he's not black either. I don't remember what he is. But she was mad. She was like, no, you need to find your black dentist. Like, that's when I say pro-black, that's what she is. Like, if you had to choose, like, every choice, she would say you need to choose black on first, black that. And see, that's just not me. My thing is, if I like this, I don't care who on it. I'm going over there. But so me and her definitely have different viewpoints. So when we debate, boy, the smoke be out, okay? The smoke be out. You should get it. You should definitely get it. And then depending on your state, you can get it by experience. So how I started with mine was I was just a legal assistant for a long time. Then I finally got with a law firm that said you should be a for hire paralegal. And I went to USC here in Columbia that had a paralegal studies program where you can just pay out of pocket. It was online. And I did that, and I was able to then officially be it. But to be honest, I didn't really have to do it. It's just kind of, having that title with it worked out. And ever since then, I work for different law firms. I'm kind of at the point in my life where I like being independent. So being at one law firm, I probably wouldn't have the flexibility that I do when I be as far as for hire. So I work with different criminal law firms, family law firms. So I can just float around, make my own schedule, you know what I'm saying? Do different things. So I like it that way. But you should definitely do it. Her boss told her she should hire me. She said, no, she's not going to hire. My own daughter won't hire me at her law firm. It's crazy. It's crazy. But yeah, you should look into it though. Like, I like the freelance, but if you want, I'm gonna be honest, it took me some years to finally create enough, because it's 3 o'clock. The legal field is just like any other field. You gotta rub elbows with people. So once I got into the rooms, going to like the network events, the pool parties, and start actually rubbing elbows with people, it got more stable. But at first, man, I was drowning. And that's why so many people will go just work for one law firm. And it works for them, but I just like bouncing around. I have a team of people that, that I just go between, and then it's be weeks I don't want to do any work. So I don't have to, because I got other businesses, but that's my passion. But I'm thinking that maybe next year, like the beginning of the year, I think I'm ready to probably go into the courthouse. I say that now. Ask me in January, but I'm kind of thinking like I'm kind of ready to get courthouse experience. So I might go back into that, but I don't know. I'm gonna miss, I'm gonna miss just like I like just having my own schedule. I was in like corporate for so long. I just like having my own schedule. Like if I don't want to wake up till 11, I like not waking up till 11. I appreciate it. Appreciate it. But all right, y'all. It's almost 3 o'clock. I need to go ahead and put this food and stuff on for my grandbaby because she'll be here in 20 minutes. I'm gonna go ahead and mute. Y'all stay here. They should start in a few minutes, but once I put everything on, I can jump back on. So just give me a few minutes because I don't want her to look. I don't want her to come in here yelling at me because she hungry and thirsty. But I'll be right back. was like, they ain't back yet. Alright, hopefully we'll be back. For closing arguments. Closing arguments is up next. Every time I see pearls, I think of the Hidden Figure movie. Lord forbid if I can't afford a string of pearls. I always think of that movie every time I see pearls. What is they doing? They wasting. I would be so mad if I was on the jury. Like, we could have been getting this done so we can get on through. Like, what is they doing? Let's get this done. Get this done. Govan trying to work out that last one deal. It's too late. Y'all, the weirdest situation is happening right now in the city I'm in. It's a infant found dead in a Columbia hotel room. Richland County deputies investigated. I seen a post yesterday where they said the baby was left alone in the hotel when they found him dead. The mama and the other toddler child is missing. I'm like, what is going on? And they was at a rinky dink motel, Days Inn on Bush River. It's rinky dink. That's like one of them little creek motels. I wonder. That story is crazy. Oh, Mickey, did you see? Not your Burger King girl got fired. But yeah, because actually, like I told you, I ran into her, and it's like ever since that story, I done seen her 100 times, seem like. But I ran into her in a grocery store, and I had told her then, I was like, girl, you tying yourself to Burger King too much, but you going to have to start doing your own thing. And she was like, they was already giving her flack about doing TikToks and stuff at Burger King. So a lot of people in the city was giving her hate because she had got like 53,000 off of GoFundMe or whatever. So a lot of people, giving her some flack. She had posted this video on Facebook. Well, I seen it on Facebook. I don't know if she posted on TikTok, Facebook, or whatever. And she was saying how people was reaching out to her for money and it was stressing her out. Because the girl still do got 3 kids, like for real, right? But boy, when she posted a video with some gold chains on, gold grill, and for those who don't know, she's actually of the community. Okay, so like sometimes she dressed like a girl, and sometimes she dressed more like what you would say like a stud. So she hadn't got her fresh haircut, had them gold grills in her mouth, and all types of stuff. So she started getting a lot of flack from the city about that because they like, oh, you must spend that GoFundMe money on girls and stuff, whatever, whatever. So the day that she got fired, she posted again. I don't see how this me person. I just don't see how people get on here and cry and record themselves. But it is what it is. But she just let it all out, and she was just like, that shit came off of Sheen. You know what I'm saying? She's trying to take care of her kids, and basically she got fired because she was late. I said, I told her when I met her in on Food Line, I had said, I was like, girl, they gonna just need one thing, because that shit went too viral. One thing, and that's what it was. So I pray she find her another job and everything works out for her. But yeah, I seen that crazy. I saw that. I actually saw her a couple days ago at the store. That's why I said like Columbia ain't but so big at all. But it was just so crazy because I had never seen her a day in my life before I did that video. Never saw her. Then it's like after I did that video, we having to run into each other in Food Line. And then like I said, since then, like we got mutual people on Facebook that know like again, I still don't know her personally. She's younger than me. But now it's like I see her everywhere. And like I said, I done seen her at the store since then. But yeah. So we live in the same area, never knew. Like I said, like never knew. But again, she is younger than me, so our crowds don't run together. But she do get stood out. Is that the bus? Oh, that's my baby bus. I'll be right back, y'all. The bus snuck up on me today. They normally only have 320, 325. Y'all, we just waiting right now. So I appreciate y'all for rocking out. But I gotta put y'all back on mute. You get the baby situated. But whenever they start, we'll be here. What you saying is mute. What's mute? Ain't nothing playing, Arthur. They're not in court yet. Oh yeah, I was putting on y'all on mute. My grandbaby just got home, so I'm trying to get her situated. What you saying? No, I'll be back, y'all. What is they doing today? Like, yes, I think every time she see me come in my office, she come up with something for me to do. Now she's supposed to be sitting at the table eating her lunch. I made sure her lunch was ready on time. Like, this is crazy. Me personally, I think if I was on the jury, I would definitely vote for the lesser charge. So I would think guilty on the lesser charge. I just don't see it being guilty on a regular charge. That's just me. I just don't see it. I think they proved the accessory after the fact and the solicitation for murder, but not conspiracy to commit murder nor murder in the first degree, in my opinion. I just don't see that. Please tell me we about to start, y'all. I see her head pop in, but it don't never start. Cook said, so we all agree he go to jail. I ain't gonna lie, Cook. Now with the lesser charges, yeah, definitely. Yes, baby.
So if you are going to have difficulty sitting, you need to leave now. The doors will be locked. There will be no coming and going during this time. Once I finish this and they begin opening statements, then you're free to move about. Hopefully you won't be doing much moving, but the doors won't be locked at that point. So if you have any issues sitting, this is now the time to excuse yourself. Thank you. You ready?
Yes.
Thank you. Officer Murphy, you can lock the door.
Somebody went to the restroom. I just heard. Everybody was ready. That one person ran to the restroom.
Always one person. Yeah, tell them to come on in now. Yes.
Jury's now in the courtroom.
You guys had a big lunch. Y'all stay awake. Are there any family or anybody over here, as far as you know, out there off the market? No, okay. Those of you who just joined us in the audience, I am preparing to read the jury charge. It's lengthy. It's gonna take me about 15 minutes or so to read it. If you're going to have difficulty sitting still during this time, I ask you to excuse yourself now. You're welcome to come back in once the lawyers start their closing arguments. But there will be no movement during this time. I'll read the instructions to the jury. The doors will be locked. There won't be any in and out. So this is the next part of this. This is my instructions to you. The law requires that I read this to you. I don't want to insult anybody's intelligence. I believe everybody can read, but the law does require that you hear it all at the same time. So I must read it all to you. Okay? State of Tennessee versus Hernandez Govan. Members of the jury, the evidence in the case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Ladies and gentlemen, the copy that you have there is for your use, so feel free to mark it up as you please. Duties of the court and jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. Formal charge, not evidence. The indictment in this case is a formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statement were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, The opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding the case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. And this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element necessary to constitute the offense. Crimes charged and pleaded. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within this offense is the lesser included offenses of facilitation to wit conspiracy to commit first-degree murder, solicitation to wit conspiracy to commit first-degree murder, accessory after the fact to wit conspiracy to commit first-degree murder. The second count of the indictment charges the offense. The second count of the indictment charges the offense of first-degree murder. Embraced and included within this offense are the lesser included offenses of second-degree murder, facilitation to wit first-degree murder, solicitation to wit first-degree murder, facilitation to wit second-degree murder, solicitation to wit second-degree murder, aggravated assault, facilitation to wit aggravated assault, solicitation to wit aggravated assault, accessory after the fact to wit first-degree murder, assault. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find a defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of the conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific felony of facilitation to wit, conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on pages 4 and 5 for you. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of a person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit, conspiracy to commit first-degree murder. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find the defendant guilty of solicitation, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant, by means of oral, written, electronic communication, directly or through another intentionally commanded, requested, hired another to commit the offense of conspiracy to commit first-degree murder with the intent that the offense of conspiracy to commit first-degree murder be committed. Intentionally intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Accessory after the fact, to wit, conspiracy to commit first-degree murder. Any person who commits the offense of accessory after the fact is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew or had reasonable grounds to believe that Justin Johnson and Cornelius Smith committed first-degree murder, a felony, and that the defendant acted with the intent to hinder the arrest, trial, conviction, or punishment of Justin Johnson and Cornelius Smith, and that the defendant provided or aided in providing Justin Johnson and Cornelius Smith with any means of avoiding arrest, trial, conviction, or punishment. Knowing means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 2 in the indictment. First-degree murder. A person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intention to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific felony of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or the results of the offense, and that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder is previously defined on page 10. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation, to wit, second-degree murder. Any person who commits the offense of facilitation, to wit, second-degree murder, is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific felony of second-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of second-degree murder. And that the defendant furnished such assistance knowingly. Second-degree murder is previously defined on page 11. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation, to wit, first-degree murder. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation, to wit, first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of first-degree murder with the intent that the offense of first-degree murder be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Solicitation, to wit, second-degree murder. A person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation, to wit, second-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of second-degree murder with the intent that the offense of second-degree murder be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation, to wit, aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. Aggravated assault has been previously defined on page 15. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit aggravated assault. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit aggravated assault, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of aggravated assault with the intent that the offense of aggravated assault be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Accessory after the fact to wit first-degree murder. Any person who commits the offense of accessory after the fact is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew or had reasonable grounds to believe that Justin Johnson and Cornelius Smith committed first-degree murder, a felony, that the defendant acted with the intent to hinder the arrest, trial, conviction, or punishment of Justin Johnson and Cornelius Smith, and that the defendant provided or aided in providing Justin Johnson and Cornelius Smith with any means of avoiding arrest, trial, conviction, or punishment. Knowing means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant caused bodily injury to another, and that the defendant acted intentionally, knowingly, or recklessly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The defendant has pleaded not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testify about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which gives you clues about what happens in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. The defendant may be convicted on direct evidence, circumstantial evidence, or both. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. To find the defendant criminally responsible for the act of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for the said offense committed by the conduct of another, you must find that all the essential elements of said offense have been proven by the state beyond a reasonable doubt. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all of the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them, if you can. For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all of the evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Expert witness. During the trial, you heard the expert testimony of Dr. Juliet Scantleberry, who was described as an expert in the field of forensic pathology. You also heard the expert testimony of Lieutenant Michael Coburn, who was described as an expert in the field of crime scene analysis. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. In giving her opinion, Dr. Scantleberry testified that she took into consideration certain statements made by other persons. Because the statements were made outside the courtroom, they may be used by you only for evaluating the expert witness's opinion testimony and cannot be relied upon as proof of the truth of the matter asserted in those statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept that opinion. The same as with any other witness. It is up to you to decide whether you believe the testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulations. A stipulation is an agreement between the parties. The parties have stipulated in 3 situations that certain matters of fact are true. They are bound by these agreements, and in your considerations of the evidence, you are to treat these facts as proved. The parties have entered into 3 different stipulations. The first stipulation was entered as Exhibit 17. The parties have agreed that the phone number 901-859-1460 belonged to Hernandez Govan. The second stipulation was entered as Exhibit number 24. The parties have agreed that phone number 901-618-3848 belonged to Hernandez Govan. The third stipulation was entered as Collective Exhibit number 33. The parties have agreed to enter into evidence certain sound bites played and testified to by witnesses Angela Arnold, Cornelius Smith, and Detective Jesse Brown. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view of reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effects of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. These are my instructions to you. We are now ready for closing arguments.
Good afternoon.
Good afternoon.
So earlier this week, you heard me talk about choices. And I warned you, you would hear a lot of evidence, you would hear a lot of voices, you would see a lot of footage, hear a lot of names. But I also told you, if you'll remember, that the name that you needed to focus on and the name that you needed to remember is Hernandez Govan. But most importantly, I told you needed to focus on the consequences of his choices. Hernandez Govan and the consequences of his choices. And the consequences. What were those consequences? Violence, death, and loss. And not just the violent death of a famous music artist, but the violent death of a human being, a person, someone whose life was marked with artistry, community, entrepreneurship. So let's take one last look at how that life ended. A life, ladies and gentlemen. But before I get into how much we've heard this week and what exactly we've heard this week, let's talk about the law, and let's talk about what the judge instructed you. Conspiracy to commit first-degree murder. That's the first count. In order for there to be a conspiracy to commit first-degree murder, there has to be four things. There has to be an agreement with one or more people to commit the offense of first-degree murder. There has to be, or number two, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acting for the purpose of promoting or facilitating the commission of the offense of the first-degree murder agreed that one or more of them would engage in the conduct which constitutes the first-degree murder. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. The two important things about this charge is an agreement and an overt act. And in the jury instructions, you heard that an overt act is done by one or more of the parties in order to carry out the intent of the conspiracy. And it must be a step toward the execution of the conspiracy. In first-degree murder cases, often enough, the overt act is the murder. Count number 2, first-degree murder. A definition of first-degree murder is the premeditated killing of another. Number 1, someone unlawfully killed the victim. 2, they acted intentionally. And 3, the killing was premeditated. You heard in the jury instruction that in order for there to be intent, there has to be a conscious objective or a desire. You also heard about criminal responsibility. Criminal responsibility, that basically means that you don't have to be the person that pulls the trigger in order to be responsible for the first-degree murder. The jury instructions say that criminal responsibility is when someone acts with the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense. The defendant acts, solicits, directs, aids, or attempts to aid another person to commit the offense. Further, they don't have to be present when the offense is taking place. Encouragement of the offense is enough. So let's talk about what we heard this week. We heard first from Erica Thornton. She told you that she is the victim's sister. They were close. And the last time that she saw him was on FaceTime. The next thing she hears that her brother was taken from her. She told you about the person that she knew, the brother that she had, and the life that was lost. A life, ladies and gentlemen. We also heard from Raul Hopkins. He told you that he had been employed with Mr. Thornton for years as his security. He explained to you the tension between PRE and CMG. And he explained to you that CMG wanted Thornton to sign with them, but he didn't. And because of that, there's been tension. He talked about diss tracks. He talked about various acts of violence committed on Thornton. And he told you about CMG and their connections. Well, as you've heard from the testimony this week, Hernandez Govan is affiliated with CMG. He has connections within CMG. CMG was in direct conflict with Thornton and the life and the legacy that he built. Govan had an in with CMG. Govan had a direct conflict with the life and the legacy that Thornton built. And then you heard from Cornelius Smith. And that's where it got interesting. He told you that he met Govan in 2021 through a friend named Bobby Carter. The relationship started out as transactional. Cornelius Smith had a pill problem. Govan provided the pills. But then one day, Govan asked him if he wants to make some money. Smith told you that, of course, he has a drug problem. He has 5 kids. He needs money. So, of course, he wants to make money. And he tells you about several discussions between Govan, himself, Justin Johnson, and Jook. He tells you that at one of those meetings, Govan told him that there were multiple bounties on PRE artists, including Mr. Thornton, but also Paper Route Wu. He told you that on one night, he was given guns by Govan. He was given guns by Govan to attempt a hit on Paper Route Wu. He told you that out of the multiple bounties on PRE artists, Thornton's was the highest. Thornton's was $100,000. So of course he jumped on the opportunity. And Smith told on himself. He told you everything. He told you chapter and verse, who was in the room and what was said. And if you're thinking about a conspiracy, who would you want to hear from the most? A co-conspirator. Someone that is in the room, someone who can tell you what happened, what was agreed to, what went on. So after he found out about what this bounty was, he talked about November. He talked about how him and Justin knew about a turkey drive that PRE hosts every November. He told you that there were a few days where they went hunting. They knew that there was going to be multiple days where the turkey drives were happening. On the 16th, him and Justin Johnson went out hunting. Wasn't successful. On the 17th, he told you that Justin picked him up from his father's house. He told you that when he picked him up from his father's house, Smith and Johnson went hunting again. And when they were at the intersection of Lamar and Airways, they saw Dolph's car drive past. Earlier this week, I told you that most Memphians know Adolph Thornton's car when they see it. And Cornelius Smith told you the same thing. They knew who it was when he drove past. So they followed the car. They followed the car all the way to Makita's, and at Makita's, they pulled around, parked the white Mercedes that they were in, got out, gunned down Adolph Thornton, and killed him. They got back in the white Mercedes, and they left, but not before Marcus Thornton shot Cornelius Smith. Smith also told you that they ditched the car. He told you that they ditched the car on Bradley Street, across the street from the defendant's home. He told you that once they left the car there, they went to 2-Lane Apartments. At 2-Lane Apartments, that's where they switched clothes, that's where they had their wound kits, and that's where Cornelius realized that he left his phone. He left his phone and he needed a ride. So he used his co-conspirator's phone, Justin Johnson, to contact his girlfriend to pick him up. And you heard that from Angela Arnold too. She told you that she got some communication from a phone number that she did not recognize. A phone number that was not her boyfriend's. It was not Cornelius's. He told her to pick her up, and she did. When she picked him up, he got inside the car. He told her that he had been hit. He told her what happened. And he told her that they killed Dolph. You also heard from Angela that he had previously told her that there was a hit on PRE artists, but she didn't believe him. But he told her. And he told her that there was a bounty. And when she picked him up that day, she learned that they had killed Dolph. They both testified that after they left the 2-Lane Apartments, they went to a gas station for Cornelius to buy some cigarettes. And after they left that gas station, they met up with Govan. They met up at the Pressure World. And at the Pressure World, Cornelius said that he got his phone back and he got out the car. Well, first he got out the car. Then he went and talked to Govan, who was already outside the car. And he got his phone back and got back inside of Angela Arnold's car. Angela Arnold also testified that the same thing happened. She's never been to Pressure World before. She's driven past, but on this particular day, she pulled in. Cornelius got outside the car. Govan was waiting for him, and they went to the back and they talked. She didn't hear anything, but she saw the defendant there. And she knew that Cornelius had to get his phone. But then, Angela tells us, and she confirms what Cornelius already told you, that they had to get a car cover. She didn't know who the order came from, but she knew that they had to get she knew that they had to get a car cover. And Cornelius testified that he got the cash from Govan to get a car cover. So that's where they went. They got the car cover. But if you remember, Angela Arnold told us that there was some point where she dropped Cornelius off on Bradley Street for him to wipe down the car. She made a loop, she came back and she picked him up. Cornelius told you the same thing. He told you that he wiped down the car. One piece of information given by two different people saying the same thing. And then, if we're going back to what Cornelius told you, he told you that shortly before he was arrested, he ran into Hernandez Govan in the street. They parked their cars, they talked. Govan was worried that Smith didn't get any money. He told Smith, I'm gonna go to prison. I'm gonna make sure you get your money. Well, of course he wanted to make sure that Cornelius got his money because he had previously asked for a $10,000 cut. He wanted his money too. Angela Arnold told you the same thing. She told you that Cornelius told her about this meeting in the street. She told you that Govan told Cornelius that he was going to go get his money. Cornelius told you that on the day that he was arrested, he was buying cake and ice cream for his daughter on her birthday. He told you how he got arrested. And Angela Arnold told you the same thing. One story, two people who told you the same thing. And we also heard from Sergeant Dabney. He was the case officer. He testified that he and other officers found the white Mercedes in the back of 1174 Bradley, directly across the street from the defendant's home. He told you, or he described the description of the car. He went through slide by slide, picture by picture, and told you that this was the white Mercedes that was used in the homicide to kill Adolph Thornton Jr. And then we got to Sergeant Browning. He went back to August 13th. He told you about an attempted shooting or attempted murder on someone named Paper Route Wood. And remember, Cornelius already told you that Govan told him that there were multiple bounties on PRE artists, including Paper Route Wood, also known as Terrence Baker. On this date, 911 dispatch received multiple calls about shots being fired in the area of 3645 Allendale Road. This is the shooting that Cornelius was talking about. The shooting that happened because of the guns that Govan provided. And on this day, there were multiple calls from Hernandez Govan to Justin Johnson, another one of the conspirators. 12 calls or 12 communications between Hernandez Govan and Justin Johnson on the day of the Paper Route Woo shooting. 8 calls or 8 communications between Hernandez Govan and Cornelius Smith on the date of this Paper Route Woo shooting. 4 calls between Hernandez Govan and Anthony Mims, otherwise known as Big Joke, the number 2 person at CMG, on the day of the Paper Route Woo shooting. And then we get to November. We're going to talk about the conspirator communications. Defense will have you believe that there was no communication between Hernandez Govan and the rest of the conspirators. Sergeant Browning testified that on November 2nd, 2021, there were 7 communications between Justin Johnson and the number for Hernandez Govan. On November 3rd, 7 communications between Justin Johnson and Hernandez Govan. 20 communications between Cornelius Smith and Hernandez Govan. On November 4th, 7 communications between Justin Johnson and Hernandez Govan. 2 communications between Cornelius Smith and Hernandez Govan. On November 5th, one communication between Justin Johnson and Hernandez Govan. 4 communications between Cornelius Smith and Hernandez Govan. And as we get closer to the murder, November 6th, 4 communications between Cornelius Smith and Hernandez Govan. November 12th, 5 communications between Cornelius Smith and Hernandez Govan. November 15th, 2 days before the homicide, 2 communications between Cornelius Smith and Hernandez Govan. You heard it from defense that there was hardly any communication between Hernandez Govan and the conspirators immediately prior to the murder. But you see here that there was communication. November 17th, the day of the homicide. On this day, 17 communications between Hernandez Govan and Cornelius Smith, the person he chose to do a job. On November 17th, the day of the homicide, 15 communications between Justin Johnson and Hernandez Govan, the person Govan chose to do this job. And 3 communications from another number of Hernandez Govan, ending in 1460. Another thing about these call records is that it confirmed a lot of what Cornelius Smith told us. Cornelius Smith told us that he left his phone in the car on the day of the homicide. Well, the call records show that there are no outgoing communications from 12:04 hours to 14:36 hours, which would coincide with Cornelius Smith not having access to his phone during that time because he left it in the white Mercedes. These are surveillance footage that we've previously seen. Cornelius Smith told you chapter and verse that it was him and Justin Johnson that did this. He told you they entered into an agreement. He told you that the reason they entered into the agreement was because of the $100,000 bounty. These records show that Cornelius didn't have his phone. He told you that he needed Justin Johnson's phone to contact Angela. And he said that he used Justin Johnson's phone, as indicated by the records. This shows that an outgoing communication from Justin Johnson's phone to Angela Arnold's phone, given the address of the 2-lane apartments. And then he told you that he needed to get his phone back. Well, whose phone did he use? There's an outgoing communication from Angela Arnold's phone saying, "This Zebra, send me bruh number so I can get my phone," to Justin Johnson. And then they asked for Quest's number. And shortly after these text messages were sent, Angela Arnold and Cornelius Smith met Govan at the Pressure World. They told you that they went to AutoZone for a car cover. Well, the phone extractions say the same thing. There was a receipt from around that time from AutoZone, or at least it looked like it was from AutoZone. Further, Cornelius told you that he wanted his money. He needed his money. And that communication with just wasn't really a thing. He would use Govan as the go-between person to contact Joe. But he still needed his money. So he found a way to message Joe, and he told Joe, "What's up, big bruh? I'm trying to get with you. I'm Govan's little homie you met before. I've been trying to let you hear my music if you don't mind giving me a call." Govan's homie. Govan's chosen person for the job. Ladies and gentlemen, we went from this person, this life, to this. You heard from Dr. Sandleberry. 20 gunshot entrance wounds to Adolph Thornton's body. We went slide by slide, picture by picture, documenting the injuries that Adolph Thornton received on the day of the homicide. She told you about the manner of death, the cause of death. She went through his injuries, the remote bullets. She told you about the wound on his face. We went from this to this. The defense will try to tell you that the police officers didn't do a good job, that the investigation wasn't complete, but yet they put on an officer as their witness. It seems as if the investigation isn't good if it doesn't cater to Hernandez Govan. It seems as if the investigation isn't complete when it doesn't benefit the defense. You heard from Sergeant Browning that this was a two-part investigation and that he came and he started to get involved when Angela Arnold talked to officers about Hernandez Govan's involvement. Her interview was December 17, 2021, a month after the murder. It was a month in before they even realized that Hernandez Govan was involved. You also heard that Justin had access to Judd, and that Justin was communicating with other people and he was doing his own thing. But that doesn't take away from this conspiracy. That doesn't mean that this didn't happen. That doesn't mean that Govan is not involved. Govan already had Chip's contact information. He already had Justin Johnson's contact information. He already had Cornelius Smith's contact information. And if you look at the text messages that the defense entered into evidence, you see that there is communication with people that Hernandez Govan also communicates with, like Joshua Taylor. Defense will also tell you that the investigation wasn't complete because there were other people involved that weren't charged. Well, we heard from Sergeant Browning that this investigation is ongoing. By definition, a conspiracy is an ongoing crime that is continuous in nature. And sometimes you just don't have all you need to charge people. Sometimes people die. You can't indict people that aren't here anymore. And if all that isn't enough, you heard from someone that was in the room when it happened. You heard Cornelius Smith. You saw the videos. You heard the testimony of Angela Arnold and Sergeant Browning that support what he's telling you. Defense introduced a video of Cornelius Smith on December 9th, 2021, the day that he got arrested. He told you himself he was a pillhead. He was high. And you saw that in the video. Even Angela Arnold told you that the day that he got arrested, when she was with him, he had taken some pain medication. And ladies and gentlemen, remember the call records. These communications don't lie. They coincided with dates of importance. The week of the turkey drive, August 13th, the shooting on Paper Route Woo. They don't lie, ladies and gentlemen. So let's get into the law one more time. Conspiracy to commit first-degree murder. The defendant entered into an agreement. What is the agreement? What is the agreement? The agreement is if you kill Dolph, you get $100,000. You need one or more people to be a participant in that agreement. You heard from one of them, Cornelius Smith. We know there's Justin Johnson, and there's Hernandez Govan. There is an agreement. And what also do you need? You need an overt act. Earlier I told you that an overt act in the murder case is often the murder. Well, you saw videos of that. You heard the defendant, you heard the shooter, Cornelius Smith, testify that he killed Adolph Thornton Jr. For first-degree murder, it has to be a premeditated killing of another. When we talk about premeditation, we know that there's no timeline on premeditation. It could be months, it could be weeks, it could be days, it could be a few minutes. All you have to do is have time to reflect. All you have to do is have time to think about what you're doing. Well, they had plenty of time. Cornelius said that they talked about this well before this murder. And we saw that the hit on Paper Route Woo was on August 13th. There was plenty of time to think and reflect about this murder. And as you saw from the video, it happened. For criminal responsibility, all you have to do is you have to have an act with the intent to promote or assist the commission of the offense or to benefit in the proceeds or the results of the offense. Smith told you Govan wanted his cut. He wanted $10,000 from Justin Johnson's cut and from Cornelius Smith's cut. That sounds like proceeds. Further, you don't have to be there when the trigger is pulled. You saw the video, you know that Hernandez Govan wasn't there, but that doesn't mean that he is not responsible for ending this life. Ladies and gentlemen, the state's burden is reasonable doubt. You heard in the jury instructions that reasonable doubt means moral certainty. You have to be certain for every element of the offense. That's my job. Certainty means that you can sleep easy at night knowing the decision that you made. It's not beyond a shadow of a doubt. It's not 100% certainty. It's not beyond all doubt. It's beyond a reasonable doubt. That is the standard. Once you've looked and reviewed all of the evidence, all of the photos, all of the videos and testimony that you've heard this week, it is the state's position that we have fulfilled our burden. We ask that you, the jury, make a choice. We ask that you make a choice to hold the defendant, Hernandez Govan, responsible for his actions. We ask that you find him guilty of first-degree murder and conspiracy to commit first-degree murder. Thank you.
break, Your Honor, just so I can get set up.
How long?
5 minutes, I just have to switch the software over and have the deputy please my podium.
Let's stand in a brief 5-minute break. They can take a bathroom break.
Court stands in recess, 5 minutes.
No, we right there.
I ain't gonna lie, y'all. Hopefully, whoever does the rebuttal is not her. She bored me so much. If y'all was in the chat, y'all see I started talking about if her hair was a sew-in, drawstring. I think she got a half a wig in the back. I don't care what nobody say. I know a drawstring half a wig when I see a drawstring half a wig. I definitely think the front is hers. Y'all, that's how much, okay, look, that's how much she bored me with that. I'm not gonna lie. I was focused on trying to figure out if that was homegrown or processed in her hair, okay? Big Will, I'll be honest. The clothes, you ain't missed much because they took like 2-3 hours to even come back. But that closing, I thought the queso closing bored me. This bored me, okay? I was over here trying to scream in on her hair. Like, I wasn't even listening to what she said. Blue Sky said she tied it together for me. It was just, when she said what looks like an AutoZone receipt, I said, If I'm on that jury, girl, I don't want to hear nothing you got to say. What looks like an AutoZone receipt. So if that piece of evidence is what looks like an AutoZone receipt, what else is what looks like? Like, I'm just saying, okay? Like, that was crazy to hear. I don't like that. I didn't like that. It bored me to death. I couldn't stay focused. If y'all realize, like, the past 10, 15 minutes, I was talking about her hair, trying to figure out if it was real or not. Like, she said nothing that... It was nothing. She didn't piece nothing together for me. Because I'm going to tell you one part that stuck out to me. She started saying, oh, well, Smith contacted Govan, what she said, the morning of or something about that. And I said, oh, but you ain't want to rebuttal on Jesse Brown on that stand when he put out the night before Justin Johnson contacted Juke with the turkey emoji and talked to him for 6 minutes. So why you ain't want to clean that up, but now all of a sudden you want to bring the highlight, oh yeah, they talk to each other. Was it about pills, ma'am? Like, at the end of the day, it's not like it wasn't established that Cornelius Smith knew Govan as his pill man, okay? His drug dealer. Well, it was 17 communications. Okay, well, what kind of communications was it? Okay. Was it 17 answer calls? Was it 17 missed calls? Was it 17 text messages? Was it 10 calls, 7 text messages? No. If I was on that jury, I'd be like, nope, let's bring the records in and see exactly what these 17 communications were. Because if you call and don't get an answer, you gonna call back. That boy needed his medicine. Okay, that boy needed his medicine. Okay, he needed his drugs. He ain't need to call Govan to ask about no Dolph hit or no Dolph murder, because you know why? Straight Drop had already confirmed what needed to be confirmed the night before. That's why he already had the guns. He already knew about the turkey drive. Oh, Junkie probably ain't know about the turkey drive. Justin Johnson knew. You know why we know Justin Johnson knew? Because he was in communication with Big Juke the night before and sent the turkey emoji and had a 6-minute conversation. And you know who ain't want to go in a ring with that? The state. The state. So again, if Street News Worldwide, who we know is a CMG affiliate at this point, if people like him is on there, yeah, Govan going down for the main crimes. Because all they want to do is make sure he take the fall. But it's definitely reasonable doubt in this case for the main charges. However, as I told y'all earlier, I do see, based off the state case, the lesser charges. I can see how that can be put together. Accessory after the fact, for sure. At the end of the day, although we don't know what the conversation was at the pressure watch, no, Street News Worldwide. You was the main one on the short bus yesterday saying he could during the presentation of the phone records. Did you not look at the stuff they was putting on the screen? Some of them calls or some of those counts was missed calls. 0 seconds, 1 second, that's a miss. So yeah, you need to go look back at that. Like on some real stuff. I know we done been joking and clowning, but all jokes aside, okay. Yeah. That was all in that conversation yesterday. It shows you, it highlighted the time of it. Y'all hold on, I gotta shut my office though because I'm listening. Miss Baby True is having a whole conversation with her toys right now. Alright. Because it's like, as much as I talk loud, she talk loud, okay? But yeah, so you got to look back at that. I mean, I doubt you're going to because you're here for one reason, to distract us from the facts presented in this trial. But on some real stuff, like, she left that very vague. But when she had the chance to clean it up to say, well, okay, so right here it said the turkey emoji. Did Govan get a turkey emoji too the day before? No, because Cornelius Smith didn't know all the details. He just knew he was going with Justin Johnson to ride around, so he thought. But in all reality, guess what? Justin Johnson already knew they was going to hit Dolph at the turkey drive. Okay? And just by chance, whoever made the call or made them aware that he was at that store, deterred them from getting to where they was going. So, again, I do feel personally, again, this is just my personal view. And since it's my channel, it's just I'm the louder one because I'm the only one talking. Everybody's in check. But my personal view, I think the lesser charges is more reasonable to put together by the state's evidence. I don't think they put a good storyline together for the conspiracy because there's too many other scenarios that could happen. And if you can come up with a different scenario, that means that's reasonable doubt. You shouldn't vote guilty. That's why the thing with the Helm situation was so important because the state wants you to go from 7:30 when Govan told Drop to pull up to the smoke shop and Juke putting Drop phone number in his phone at 9:08. They want you just to go from that to that. But they want you to forget that Helm takes Justin Johnson at 8:38 and told him he talking to Juke. So obviously he hadn't made it to the smoke shop. And then less than 30 minutes away, they got each other numbers. So some could think like, okay, so you want me to look at an hour earlier text. So how we not know when Justin Johnson got to the smoke shop, he didn't run into Helm first? And that's who made the introduction. But they want us to believe it was only Govan. Now, it could have been Govan, but the problem is we got a whole nother person in play now. Boom. You want us to think that Govan was the only one sending these boys out after Dolph. But then you got text messages from TZ saying, hey, we about to slide on Dolph and them to straight drop. At the end of the day, you want us to go down a rabbit hole again that this is about CMG PRE beef. Dolph ain't want to sign the Gotti, so CMG was after everybody to take down PRE. So the nigga that want to be a rapper, we gonna overlook the fact that he gonna do whatever to try to get on CMG. They still ain't tied together Why the world is Govan even caring about a CMG or a PRE? They still ain't linked that together. Yes, we know they knew each other. They haven't established, was he like what was he to CMG for him to care about the beef? For him to care about the beef, like on some real stuff. I would have had liked to see the state do that. Because if you were going to start off with saying this is about some rap beef, then the only connection to the rap beef I'm seeing is that, okay, one of the shooters wanted to be a rapper. Boom. Now you got an executive from CMG in the mix. Okay. Now you got another dude that obviously he ain't trying to be no rapper, but let's just go with what they say he texts on IG, you know what I'm saying, to Jook about some music. I mean, of course, I doubt he gonna text about a murder, but hey, at the end of the day, he wrote music. We got to go with that because y'all didn't prove that music means something else. So all I'm saying is it's shaky. Even the judge said it's shaky. Okay, it's shaky. I'm not about to sit here and say that this is an ace in the whole case. Okay, it's just. Yeah, and I definitely, if it happened, I want my $100. And no, I'm not betting back because I don't bet, I don't gamble. Okay, but I surely will take your $100 for sure. But yeah, it's definitely some reasonable doubt, and I feel like it's strong reasonable doubt where you cannot on the main charges. Now, like I said, I'm fair. I don't got no dog in this fight. The lesser charges make more sense. Accessory after the fact and solicitation to murder. Because at the end of the day, like I told y'all earlier, the defense did not question the fact that Smith didn't meet Jook at Govan's house. So they didn't question that. So at the end of the day, I will go with solicitation, but conspiracy, man, too much going on with that. Too much going on in that. Brinson said, dude ain't the mastermind, and the person who is there definitely fumbled this case. Memphis got blood on their hands. Dude said conspiracy is more than one person, Mickey. With all due respect, read the definition of conspiracy. Read the definition of solicitation. I mean, what we doing? What we doing? The judge just read the definition. With all due respect, y'all like to add that on there.
You can go back on your record.
Or is back in session?
Hey y'all, when I be working on trials, I be like them women back there in the back. That's why I be sitting there. That's where I be sitting there in the courtroom.
Yes. Jurors enter in courtroom.
Ladies and gentlemen, I want to thank you for your time this past week. You've been stuck in a hotel room with no TV, no internet, just to make sure that your mind doesn't get jaded with regards to anything you see on the press. We talked about first appearances. I also talked to you about the fragility of the criminal justice system, and I hope you can see why now. I don't know anything about the 16 of you, which 12 are going to be the actual jurors. Mr. Govan doesn't know. I don't know if you have kids, if you're rich, if you're poor, if you live in Orange Mound, if you live in a nice part of Memphis. You see that? I'm from Atlanta. But all I have is trust in you because you said you are peers to Mr. Govan. Mr. Govan, stand up. Come sit at the table and let them see you. It's time you're not marginalized anymore. Sit there while I talk. The fragility of the system is solely based on you. I don't know in what world the prosecution is living in this case, because unless they were watching something in the multiverse where other witnesses were saying perfect things, I don't know why we're here. You all should be embarrassed as a community that your district attorney thinks this evidence is sufficient to take a man's life for first-degree murder. You should be embarrassed that this is the person you voted for that brings this type of case. Just embarrassed. Many of you said you had a problem with the criminal justice system because too many people go free or they get bond. What they don't tell you, what the government doesn't tell you, and the press doesn't cover, is this is what happens when you don't have an advocate that knows what the hell they're doing, checks all the records, fights for you, and shows you that he didn't do it. That's just another black man that is of no value from Orange Mound, that's poor, that has never had a voice in his life. I'm fixing that. My team is fixing that. He is indigent, he is poor, and he deserves better than he's gotten in this case. Sergeant Browning, who's the biggest liar that I'm going to go through with you, says we can't kidnap people and bring them in for questioning. What did Angela Arnold tell you? They threatened to have me arrested being involved in this case if I didn't talk to them. We went to the airport and we figured he was going to assert his rights, so okay. What about the second guy, Mr. Sears? His lawyer said he wasn't in town. When you talk about accessories and all this other stuff that the judge has told you about, how about the people that helped hide them? How about the people that helped give him new clothes? How about the people that gave him medical treatment, assuming they were even shot? Because you know what? I don't even know if he was shot, and I don't even know for a fact if that was the Mercedes used in the murder. Because why? There was no blood in the Mercedes. Had there been any blood, to back up what Cornelius was saying, they would have plastered it front and center to you. Their own lieutenant from crime scene that they did not call tells you no one wiped that car with bleach because luminol or the other star thing, whatever it was, would show that. And if somebody said, I poured bleach on a towel and I wiped that car down, they would be. I don't know what world we live in. None of you would buy a pack of gum based on the word of Cornelius Smith. You wouldn't do it because he's a lying piece of so-and-so that will do anything. Lie to his pretend grandmother, his family, his girlfriend, anybody. And I'm going to prove it to you as we're going to go through a few more slides. And Detective Browning may even be worse because that's just pure evil, trying to put people in prison based on shaded evidence. Dabney told you the truth, that we didn't do all this other stuff that we should have done. We didn't get around to it, was his quote. He wasn't happy about it, but he told me the truth. The other guy couldn't answer a yes-no question. It was always dodge and deflect, which is what they're taught to do as part of their training when they go and come and testify. These are the people that are policing your streets. You should be ashamed. The only crime that's being committed here today is in this courtroom. It's been committed for the last 3 days. This poor man will never get his life back because of what's happening. He's been threatened because they all think he's involved in the Young Dolph murder, and everybody loves Dolph. Dolph has been threatened for years. He moved away from Memphis 5 years ago. He had 3 old bullets in his body from other times he'd been shot at by people, being in Charlotte, being in Los Angeles. Everybody knew there was a price on his head. There is no plan. There is no plan. I tell you why? Because if I made a plan and I go back to my house across the street with a murder car, are you freaking kidding me? And then they go ahead and call around to see where can we go to get changed. We are across the street from the guy that planned the murder. We don't go to his house to change clothes, but we ride around town until somebody picks up the phone, as you see from the records, and we go to 2 Lane while we're bleeding and doing everything else. Have you seen a single photo of Angel Arnold's car, the Mercedes, or anything that had a drop of blood in it? As if they said, Cornelius is a pathological liar. I don't even know if he got shot on that day, because you have to ask yourself, there is a bullet lodged in his shoulder, as he told you. For a freaking month, he didn't get infected. He didn't have a problem. He just put some bandages on it and it was okay. Please, for the love of God, this is insane that I even have to talk to you about this. If this is what is sufficient evidence for first-degree murder, we're all in trouble because you're going to be next. Assault, all these charges they gave you, there's 15 different ways they're trying to convict this guy. I didn't assault anybody. He didn't assault anybody. He didn't aggravated assault anybody. He didn't solicit anybody. He didn't facilitate anybody. He didn't act at whatever age anybody. It didn't happen. All the text messages, all the phones, everything that said with you. Have you seen one single message from Justin Johnson or Cornelius Smith that says, hey, bro, let's go shoot somebody? I gave you tons of messages over their objection where Justin Johnson is talking to other people, talking about killing people. They weren't discreet about it. Where is a single message to Govan from any of these people over the course of 4 months that says, we're going to do this? Can we get your permission? We're going to give you $10,000 or $38,000 or $50,000 or $100,000 or $1.5 million. You think if they would have had it, it wouldn't have shown it to you? They know the truth is the text messages are only about music because he's friends with Justin. I'm sorry, Justin's not a nice guy. They all live in the same neighborhood. They've all known each other. Just because you have, quote, communication doesn't mean you're in the conspiracy to kill someone. Cornelius. Let's go over the slides. This will speak for itself, and I'll let you think about it because I've hammered the point about didn't prove it. I don't need you to say he didn't do it if you don't want to, but they absolutely, for God's sakes, didn't prove it. Let's go to the next slide. All right, so excuse me. So you see this, what the government says? Angel Arnold's phone? Absolutely. This is Star Defense Exhibit number 1. This C, bruh, assuming C is Cornelius. Send me bruh number so I can get my phone, right? He needs to get his phone. Next slide. Quez's number. Guess what he told you is the one honest thing he said. His brother's freaking name is Marquez Smith. They call him Quez. His brother is the one that got the phone at best. You know why? Because they had TBI Gardner up here. They asked him to do location data analysis on the phone, right? You guys remember all that? And they did it solely for Cornelius's phone, and they did it for Justin's phone. But yet they didn't show you any location analysis. All they have to do is say it's in that general area, this is where the tower's pinging. Because calls are being made. Where was this call from? Where was his brother Quez? They just BS you constantly, and here I am fighting for this man's life. He is your peer. You need to be here protecting him from this. This is the crime. Next. So I'll just go over a few things on Cornelius Smith. I think that was pretty obvious from his statement. Go ahead, Robert. I think all this is obvious. You got a sociopath on your hands that's out there on his daughter's birthday. Is he intoxicated? He's not intoxicated. Just ask the prosecutor to tell you a straight answer, honestly. Do you even think the prosecution would take advice from Cornelius Smith on anything? But it's good enough for this poor man's life. My dad used to tell me, you know how somebody's honest? Would you loan him money? Raise your hands if you're going to loan Cornelius money. Because that's the crux of the whole case. And a bunch of BS cell phone records that don't tell you anything. Because they didn't do the location analysis. They can't give you a single text message that says we agree to do anything. And we know it was at least 4 months between the so-called meeting between multiple shootings that Cornelius did and when Justin went out. Next. And if you're not biblical, I'm sorry, but growing up that way, it's just used to be told, the truth never changes. You don't need to remember it. You don't need to practice it. While we're meeting with prosecutors and lawyers now report, I don't want a deal. I'm just here out of the goodness of my heart. I'm going to get a mandatory life sentence. Insane. Next. We also showed you the letters from Cornelius that he sent to his sister saying, I've got that lawyer that you paid for. It's this guy's lawyer, and that guy cooperated against somebody else and walked from a murder. That's what you have in black and white in Cornelius' own handwriting. And that is what all of you said when I said, what would you do to avoid a life sentence? You guys said, probably anything. All right. We know this to be true. Next. And we know all this to be true. Next. And we all know this didn't happen. It just didn't happen. His story just didn't happen. And both he and Angela said it. Because, remember, he had talked to his family to go see Angela between the 14th of December, her first statement, when she didn't know nothing about nothing, and the 17th of December, when she's decided. And note how they have to prompt her to ask, could it be somebody with the name Q? And note, they had to ask her, didn't he forget something? Didn't he tell you something he might have forgotten or something that he needed? They had to prompt her. This is 30 days after that. You don't have to remember the truth. This was the biggest day in somebody's life, you would think. I just killed Dolph. I'm running around, and she can't remember who the guy was that picked up the stuff at pressure room. Oh, shocker. There's a few cameras at pressure room. They had the absurdity to tell you, well, do you know how long the camera might be working or how long it records? You know how to find that out? Maybe go there and ask them. We've had Ring cameras and other things like that for a decade. It always goes to the cloud, and most likely it's going to be preserved for a year or so, which is what most businesses would do, especially in a dangerous part of town. And guess what? You have those crazy MPD cameras everywhere. If you drive home, you'll see them. It's got the little blue thing coming out of it. I've showed you some of those from right around the area. Nobody checked any of them. You don't have to take my word for any of it, because everything I'm going to tell you is going to be backed up by independent evidence. You don't have to trust me for anything. You don't know me. But I want independent proof before I get in bed with a murderer with a machine gun that shot a guy 20 times in broad daylight, and thank God he didn't kill anybody else in that police shot. And this is who they're in bed with. Next. All right. Sorry, I just have to calm myself down. The other things with the shenanigans, as they try to tell you, is when the officer accidentally said, I don't even know if it was Justin something, I think he said that, but he said, AKA Dolph, I'm sorry, not Dolph, in that. And Mr. Cornelius says, yeah, I met him through miscellaneous in a moment of weakness. And you know, when I asked about it, you know, you smile. You have murdered somebody, and we're up here chuckling. The government's chuckling with him, and he's laughing at me, making smirky faces, and says, I saw you on TV. That's the behavior you want from a guy that took a machine gun and murdered people. In fact, his definition is, I didn't shoot that many people because sometimes we didn't get the shots off of the gun can. And you're going to make a deal. Not a single text message anywhere. Take my word for it. And oh, by the way, I think he's a federal snitch, but I don't know if I believe that or not, because he's never snitched on me. All right, next. And then he also tells Uncle Ron, maybe we should have gone and talked to him, whoever Uncle Ron is. Yeah, but I'm not a policeman, and I'm not trying to put anybody in prison. That there was a bug on him, that he's a snitch, and so you're going to have to plan a big old murder. Next slide. So we know he paid for his lawyer, and we know that was a team issue. And you know the absurdity of the prosecutor in the last statement. They're going to get to go up again and call me every kind of name in the book, which is fine. I can handle it. I will take those arrows for this man that I've grown to care about over the last year and a half, because he didn't do it. They had the audacity to tell you we can't indict somebody that's dead. Should have died 2.5 years after all this happened. Remember, Justin Johnson was indicted in December of 2021, about a month after this happened. Cornelius was indicted in January of 2022, about a month and a half after this happened. There is no investigation done in 2023 or essentially 2024. It was done. They indicted and gotten who they wanted. So at some point, you got to ask yourself, what happened here? And I have no idea. It's not my burden to prove their screw-ups. If you believe Cornelius, he says Jook is the one that set it all up. His girlfriend says that. Then they backtrack and say, well, he was there and he set it up. He didn't go there. None of it happened. Keep going. And with Miss Arnold, I don't know how you date a murderer that's been domestic violence me, stolen from me, done this. I don't know what her issues are, at fault or not. She's just doing what the man's telling her to do. They've had visits, they've talked about it, and her story is still iffy as far as that goes. And God bless her. I hope none of you would be with a essentially soon to be convicted murderer for 4 years after all this happened. Right, next. And the interesting thing there was, we keep talking about the car on Bradley. Bobby Carter also lives on Bradley, and Bobby Carter was involved in the shootings with Mr. Cornelius. And in fact, Angela says Bobby was involved in the Dolph shooting as well. Next. All right, we already know this as far as the jail calls and the family coming to see her. Next. And we also know about the varying amounts of money this whole thing was worth. So now we get to the meat and potatoes of a few things I want you to consider. Remember, the two pillars to this case is you got to believe Cornelius Smith. And the judges told you over and over again, you have to have that agreement. You got to believe it's out there, otherwise nothing. They've come up with 15 different methods, from murder to second degree to 30. I don't care if it's 47th degree murder. None of this stuff happened. There's no assault. There's no solicitation. There's nothing. So let's talk about the detectives. Next slide, please. All right, so the Detective Browning, the all-powerful Detective Browning, told you that Govan last talked. Oh, I'm sorry, I got my slides mixed up. We know Dabney, who actually I respect him, had a nice talk with. He said they didn't do it straight up. Didn't try to sugarcoat it. We just didn't do it. Didn't go to pressure roll to confirm anything this man was saying. Tells you straight up, we didn't go to AutoZone. Tells you straight up, there was no relevant evidence of AutoZone. So this mystical receipt that's all crumbly and you can't tell what it is, that's supposed to be some kind of evidence now. And they didn't get around to investigating Joe, who was on Team Cornelius or whatever you want to call it. At least he was honest enough to tell you that. So these are the slides you saw yesterday with Detective Browning. And this is where the evil of it all comes in. He did these call detail records for you. And this slide cuts off at 11:16 at 3:01:17. Right? They stopped it right there. I've highlighted for you. That was the slide. You might wonder, Manny, what's the big deal about that? It's just some phone call to somebody, no biggie, right? Yeah, he's talking to Cornelius here, no problem. But guess what? If they would have given you the full story on the slides where they try and bias you, next slide. You see, on the same 11:16 at 5:37:15, this is Jook's number. And he spent a 6-minute phone call. It's not on the slide. I had to pull that off the call data records that you're going to have a thumb drive. You will never find it or see it because there's thousands of pages of call information out there. But you see, this thing stops up there at 3 o'clock. They don't tell you this part. That Justin Johnson talked to Jook before the murder and also sent him a turkey emoji. If you are a law enforcement officer, your job is to investigate and the facts go where they may. You don't have a job to convict people. That is why I respect Dabney. He made a mistake, he owned it. Browning is a liar, pathological liar through and through. Next slide. So okay, this where Browning also told you that they last talked to Govan on November 5th. You remember an opening statement that told you Justin Johnson had not talked to Govan for at least 2 weeks prior to the murder. No communication whatsoever. But they try to tell you that, oh yeah, on November 5th, he must have talked to Govan. And then Cornelius last talked to Govan on November 15th. Just remember those. It was very specific that they argued. So let's go to the next slide. So what you'll see is on November 5th of 2021, this is Govan's number. Hernandez Govan. He's getting a call from Justin Johnson. You see this? This is the communication they had on November 5th. How many seconds is that phone call? Let me break it down to you. Zeros. It never went through. There was no phone call for at least 2 weeks. No text messages. Nothing. And this is the guy I'm supposed to be planning a murder with the most famous person in Memphis. Are you kidding me right now? All right, next slide. So there's an old movie that said the tail wagging the dog. You've got Cornelius telling him what they want to say as he tells you he likes to do. And everything they're trying to do is back up what Cornelius says. There is no explanation why they didn't go talk to Joe or bring him down for questioning. There's none. There's none. All right, next slide. So just go through here. That's 10, 12 phones out there. Go through all of them. Find me a text message where a single human being tells Hernandez Govan, we need to do something. That's evil, that's violent, that's criminal. Browning told you he just came up with these slides just a day or two before all this happened, because this is 4 years after the fact. And I'm seeing the slides for the first time. And the slides are complete BS because they keep misleading you about stuff. And so if the incriminating text existed, they would have showed them to you. They've cut off records in half so you can't see the rest of the story. Go to the next slide. We know he agreed with me that these text messages, there's thousands of them with Justin Johnson. It's about music because Justin was in videos and all that stuff, and Govan was there. He was a colleague, a friend, whatever you want to call it. That doesn't make you a murder criminal. And we know he talked to Cornelius about pills. 14 communications is what they call it. What they don't tell you is how many of those 14 actually went through. What were the phone call codes? Remember, 11 is important because that goes to voicemail, or it could be two-way, or the call goes through properly. Is it a text message? I don't know. Last night I'm talking to my daughter just about her boyfriend. Between okay, yeah, no problem, I had 16 communications with my daughter in a span of like 3.5 minutes. It doesn't mean anything, and you can't presume you know what the communications are about if, in fact, for the love of God, they even went through. I've already shown you one bald-faced lie about the government right there. There was no call on November 5th. Keep going. So we have the turkey emoji, we have the 6-minute phone call, and you know this secretive plan, PRE, as his bodyguard told you, this is social media. They do this every year. This is what they do. Remember, he's a man of the community. They put it out there. Everybody knows they're doing turkey emojis every year. Most of you probably know about this. Next. All right, skip this. Let's go to the next one. And then we have this. It's not anything I could get voluntarily out of that man. We have to press and press and press to show that Justin Johnson already knew Joe. Didn't need our guy to do any of it. That is why you will never see a single text message of any incriminating nature. Because I can promise you, had it said anything, a comma out of place, they would have it plastered up here on the board saying, see, we got him, we got him. Next. All right, so Garner, he said, MPD asked me to do what? Location analysis on a couple of phones, Justin's and Cornelius's. All you have to do is plug in a number on a computer. We could have done it. Hey, the phone's pinging off pressure levels. Maybe more believable. Even if you choose not to go there, you can just ping it. You don't need the actual phone if you've gotten rid of it, because you can just order the CDRs from the phone company, as he told you. He did cell phone tower analysis for a very short amount of time, and then it just stops. Is this kind of investigation in Memphis we call sufficient to put somebody in prison for life? And none of the other phones were done. Where was Chuck? Hell, where was anybody else in this case? Next. All right, we've got this, so covered that. Go next. We covered the AutoZone thing. I just respectfully ask, if the audacity to put a crumpled receipt in front of you that you can't read and just say, Detective Brown, I just know this now. It is not mentioned in any police report anywhere. As I asked him, he couldn't answer the question. But now suddenly it shows up in the phone. We know Dabney knew this was garbage because they talked about the auto part from earlier. You can't put a date, time, place on it. It's all what they call red herrings to mislead you. Think there's something nefarious out there and just use your imagination to convict people. You would never let this happen if it was somebody you cared about when you saw this. Some of you might be supervisors. If this half-assed work is what they brought to your desk, you would fire that person immediately. And don't say you wouldn't, because you would, because it makes you look bad. This whole county is a freaking embarrassment with regards to this trial, and the whole world is watching, and this is what we've got. All right, next. And then the last thing is you got to ask, if I set up the plan, I don't know if I'm having the murder car come to my house. And if I am having a murder car come to my house, why don't people just come inside and change clothes there instead of riding around all over town trying to find a place to go change? And again, I know you may think I'm crazy, but there's no blood in that car. Was this even the right Mercedes as far as that goes that they got? You remember Treon Ingram and another gentleman had stolen that Mercedes a while earlier. Treon Ingram didn't come and testify because Treon Ingram picked up another murder right after that. Where did the blood go? Cornelius told you point blank, no ifs, ands, or buts, and the girlfriend. I took bleach, I wiped it down. And the lieutenant from CSI with 28 years of experience says that just didn't happen. Where's Angela's car? Remember, she said he was bleeding all over. Where's the evidence of any of that? All right, next. So all I do is cross my hands and beg you guys, he is your peer. There is no evidence here. You would never accept what's happened in this courtroom in your own personal lives to make any decision of any kind. And he deserves that same respect. There's nothing here. They're going to get to come back up again. Remember, we've talked about first impressions. You need to use your minds, your eyes, your ears, and your noses and call the Smith test BS on this whole thing that they're about to give you yet again. There's nothing here. There's no solicitation, there's no facilitation, there's no assault, there's no murder, there's not a text message, there's not a phone call worth a damn, and they aren't telling you the story. Make them tell you, why didn't we investigate Chuck? Make them tell you, why didn't we investigate all the people that helped these folks escape? And if you want to talk about conspiracy, how did he conspire or solicit Justin Johnson? Have you heard anything about that? Who's Jamarcus Johnson? Have you heard a single word out there? They're all together in a conspiracy. All you have is Cornelius' word. He's the linchpin in this whole case, and none of us would trust him. And we sure as hell wouldn't want him much. And then we have phone records that actually exculpate him. But if you make it all nefarious and have a sleazy detective get up there and talk about it, it sounds pretty good. He didn't do it, but you don't have to take my word for it. They didn't prove it. If this case gets a conviction, then I just need to stop being a lawyer because the system is shot to hell. Thank you.
Girl, don't get your ass. Oh, that's not the same girl. I'm gonna say, don't get your ass over there to talk to me.
Are you kidding me right now? This just called the whole city of Memphis stupid and dumb. Everybody from the DA to the police officers to the prosecutors, he called y'all dumb. Called everybody, all one of them dumb. Are you kidding me right now? This case is not about the prosecutor. This case is not about Juke. This case is not about Justin. This case is not about Cornelius. This case is about Hernandez Govan. He is the person on trial, not the city of Memphis, not the DA, not the prosecutors, not you, Hernandez Govan. That's who we are here about today. That's what this proof has been about.
Embarrassed. Who should be embarrassed? Hernandez Govan. He is the person that made the choice to get engaged in this conspiracy. He made that choice. We've talked about choices. There are a few things in life that we can control, and our choices are one of them. What choices did Hernandez Govan make? You've heard that over the last few days of the choices that he's made. His choices led us here today. All right, police, they say they didn't do a good job. Convenient story. Something, novel. Because they didn't arrest everybody has to be arrested for them to do a good job. There was a twofold investigation. Sergeant Browning and Sergeant Dabney both told you that. It's very convenient that that part was left out of the defense's argument. There's a twofold investigation. Homicide and MGU, those are two different entities within the Memphis Police Department. There was an ongoing investigation. And as Ms. Williams mentioned in her closing statements, this is a conspiracy. It's ongoing. To let you know that they were still investigating, look at the call records. Look at when those call records were received. Now, defense will have you believe that, there are thousands and thousands and thousands of pages of call records. There are. But guess what? You'll have access to all of that, and they're on a flash drive. You can search. You can put in the numbers that were given to you. When things happen, what happened with those calls. They're there for you. There's no hiding. There's no putting them aside. They're there for you to look at. So I wanted to clear up that misstatement. The focus at the time of the incident, November 17, 2021, was on a homicide. It was not on who went to AutoZone or who went to Pressure World. The focus was on a homicide. A person was dead. The defense never mentioned that we are talking about a dead person. Dead. It's everybody's issue and fault but Hernandez Govan. The police didn't kill Adolph Thornton. Cornelius and Justin killed Adolph Thornton. But who put them together? Hernandez Govan. Look at the PowerPoint presentation that Sergeant Browning provided. It has communications that contact log was put in there for Juk and Justin on the same day, about July 27th, around that time. They looked like they exchanged numbers. And if they knew each other before then, they wouldn't have had to exchange numbers. They would have already had each other's numbers. Look at that. Look at the call detail records of Cornelius Smith. You'll see about the first time he had contact in his phone anyway with Hernandez Govan was about July 25th, 2021, around that time. All you have to do is plug the numbers in. It's not rocket science, as he'd have you believe. Hernandez Govan put these individuals together. In Govan's investigation, Govan's role in this conspiracy, as far as MPD was investigating, really didn't start until Angela Arnold gave a statement. Now, if we are to believe anything Angela Arnold says, then we are to believe call records, which Sergeant Garner said they don't lie. They're the records. They are what they are. So we can't believe that. we're not supposed to believe Angela either. We're not supposed to believe anything that's happened. The records are what the records are. But they bring in Sergeant Coburn or Lieutenant Coburn. Officers are bad. They don't do a good job. But he wants you to, well, this officer did a great job. Just this one that we bring in. He did a great job. Cornelius will tell you, he didn't just get a whole thing of Clorox and pour it all over the car and wipe it down. He said he sprayed some substance on a towel and wiped. He was still hurt. It was in the dark. He was in a rush. He was scared probably that Govan was going to come out and shoot him or do something because he was across the street from his house. But you want us to, defense wants you to believe that all the officers are bad, they did everything wrong, except that part. The investigation was ongoing. Look at the call records. Look at when they were done. And you can still investigate. Because you want someone arrested tomorrow, it doesn't mean the evidence is all there. At this point, Jook is dead. Bobby Carter's dead. Joshua Taylor's dead. We can't arrest them. We're not digging them up from the ground. They are dead. That point is dead. Browning just analyzed the numbers that were there. Garner said the records are what they are. They come from the phone company or from the phone. All Browning did was analyze it. To say, hey, these many calls came from this individual, this many contacts. That's all Browning was brought here to testify about. But because those records show Hernandez Govan communicating with the conspirators throughout the summer, throughout the fall, from July until November, well past November 17th, at least November 20th of 2021, oh, Browning's a liar too. And when all he did was analyze the records. The records were made by Mr. Govan. Defense also brought up that basically Justin Johnson had access to Jook on his own, basically. But we know that Govan made that connection. July 27, 2021. We know that. We see that in the call records. We see it. Govan already had Jook's information. Govan already had Justin's information. This was by July 27, 2021. Govan had Cornelius's information. Govan texts Justin address to Jook's smoke shop. And the contact was created between the two while they were there. But guess who did not have contact with Jook? Cornelius. He was a part of this conspiracy as well. And he got up here and he testified and he told you that he really didn't have much contact with Jook. Guess who he was communicating with? Hernandez Govan. That's who he was communicating with. And let's look at the definition of conspiracy. You just have to create that at least with just one other person. So if you take defense at his word that Justin Johnson had other conspiracies going on and this was something separate, Hernandez Govan was still egging on Cornelius. He promised to give Cornelius pay. Cornelius didn't have direct access to Jook. He told you he was trying to still get his money. December 2nd, 2021, he sent a message from Angela Arnold's phone via Instagram message. He said he couldn't just straight out put that, hey man, I want my money. I did what I was supposed to do. He
said he sent him a message trying to get his attention. A week later, he's arrested. But Hernandez Govan was the link between all of them. Hernandez, that's still being investigated, but if the entire hit came from Juke, it was communicated to Govan, who then put it out to Justin and Cornelius. Hernandez Govan did that. The defense also makes the assertion that for 2 weeks, Hernandez Govan didn't have any kind of contact with any of the people who did the killing. He didn't have contact with Cornelius. He didn't have contact with Justin. The phone records will tell you that that is not true. It's simply not true. The phone records are there. There was contact. There was contact the day before. There was contact the day before that. There was contact days before that. And even if they didn't talk on the phone, what is stopping them from walking to this house? Communication is there. Doing everything to take away from the fact that this trial was about Hernandez Govan. And there's nothing that says, okay, if we don't talk within 2 weeks, that all of this is out the window. Nothing in the jury instructions that the judge gave you or read to you said, all right, this conspiracy ends if we don't talk in a week. This is not girlfriend and boyfriend stuff. This conspiracy was ongoing. Hernandez Govan is just trying to pull himself away at this point. But this, Justin and Cornelius, they were put together by Govan. It's been reiterated several times. All right, even if you believe what the defense says, say Justin was conspiring with others. Okay, two things could be true at the same time. But what we do know that shortly before the turkey drive, Cornelius said that Hernandez Govan called him and Justin together and was like, hey, y'all know this turkey drive getting ready to come up. Y'all ready? Y'all ready to make this money? Y'all ready to do this? Cornelius told us that. The call records, they show that there was some communication shortly before the turkey drive, the week before Thanksgiving. And Govan just reminded them, this is your mission. This is what you're supposed to do. If you want this bread, you need to make it happen. You need to make sure that you take care of that family that's been out there. You need to make sure this is what you do. So Justin chose, even if there were other conspiracies, just if there were other conspiracies on the side. On November 16th, 2021, Justin Johnson chose Cornelius. He chose Cornelius. The same Cornelius that he was introduced to through Hernandez Govan. That same day, Justin Johnson sent Juke a turkey text. It's the same text that defense has entered into evidence. He sent that on November 16th. The defense just showed you there was some communication with Juke on November 16th. On November 17th, again, the day of the murder, the day that Dolph was killed. Even if there were, again, other conspiracies, Justin Johnson chose Cornelius
Smith to go on a hunt with him. He chose to go on a hunt with him. He chose him the day before. He chose him on the day of. And Cornelius Smith said the only way he knew who Justin Johnson was because of Hernandez Govan. He told you that several times. Then we talk about Cornelius. Let's talk about his testimony. Cornelius was the state's witness. Prosecutors are probably not going to be hard in screaming at their own witnesses. The point is to get the witness to talk so that you, the jury, can understand what's going on. They're a witness. Cornelius, at this point, has already testified in a previous trial. He has no reason to come in here and lie to you about what he did. He said and told you, as you watched the video of the murder of Adolph Thornton, he told you, that's me with the big gun to kill him. Now, if any part of that is if he's to lie about, why lie about him killing somebody? That's where you lied. He didn't lie about that. He told you. I mean, I did. But I wouldn't have known Justin Johnson except for Hernandez Govan. And he put us together to get this done. He told you, the defense attorney, at least several times, that he was under the influence. You saw the video. Cornelius Smith was up there. He was high. Even the questions that were asked of him were confusing. And he told you, said, I don't remember. I had taken some pills, and we learned you've been taking pills. So why at that point say anything different? Even Angela Arnold said he took some pills that day. Yeah, he may have been fine, but he told you, I've been doing this for a long time. It may not affect me the same way that it affects someone who doesn't take pills. But in addition to the pills he was taking, he took some Tylenol PM. Defense tried to make it seem like it was just, a headache medicine. But he was getting that edge. He saw the end of the road coming for him. He knew the marshals were behind him. He knew that. He's taking them pills. So they try to get a statement out of him that day. He's all over the place. He's confused. Doesn't really say much to him. But he gives a statement eventually. And he tells you on the stand what happened. How Mr. Hernandez Govan set all of this in motion. And defense, paints him as a liar. Cornelius said his game with the women. Well, Angela, she's still with him. Some kind of game. Letitia Jackson, kid's mother, he had enough game where she took his phone. He handed over his phone to her the day he got arrested. And Miss Ferguson, the neighbor, she said, he's a sweet baby, just sweet as he won't be. Just love him. He helped her out. She didn't have a bad thing to say about him. Said he didn't give her $500, or someone didn't give him $500 for Cornelius. How do we know Miss Ferguson is the neighbor that happened to? Live on the street, there's several neighbors. But he brings sweet little Miss Ferguson in. We had nothing bad to say about Cornelius. Cornelius, this testimony was backed up by Angela, by the evidence and phone records, by the murder, All of that is backed up. Okay, you have looks like an AutoZone receipt in a picture crumbled up. You have access to the picture of their receipt. It was a picture that was in the phone that Cornelius took. It was in Browning's presentation. Look at the receipt. Blow it up. Stretch it out. You'll see that was taken, it looks like AutoZone, and it was a receipt from November 20th, 2021. In the end, all of this points back to Hernandez Govan. He got the ball rolling. He kept the ball rolling. He kicked the ball in the end. He introduced Cornelius Smith and Justin Johnson for the purpose of taking out members of PRE. One member of PRE being Adolph Thornton. That's where the conspiracy started. Again, all fingers point back to Hernandez Govan. Justin, Hernandez Govan. Cornelius, Hernandez Govan. Juke, as the defense keeps wanting to throw out, Hernandez Govan. And why go to Hernandez Govan house after they commit the murder? Because that was comfortable for them. No one ever said these were the smartest killers. They didn't plan on getting shot. That wasn't part of the conspiracy. When we get shot, we're going to go here. But they'd already had the getaway car at Hernandez Govan house. So they originally met at Hernandez Govan house back in July. If they would ever meet up during the time of the conspiracy, from June of 2021 until March of whenever they were arrested, they would meet at Hernandez Govan's house. Want to go shoot a video? Go to Hernandez Govan's house. They're all in the video. Park your getaway vehicle? Go to Hernandez Govan's house. Park your murder vehicle. Hernandez Govan, that's the person. Now, why did they not go in? Maybe he wasn't there right then. Maybe he was like, someone went down, I'm getting out. Who knows? But we know what happened. We know where they went. We know that the murder vehicle was parked there. We know that the getaway truck that they used to get somewhere else was parked in front of Govan's house. We know that. Even Cornelius Smith told you, Cornelius Smith told you that Justin wanted him to meet him on the day of the murder. He wanted him to meet at Govan's house. Cornelius said he couldn't get over there. So Justin came and picked him up. Again, all of this going back to Hernandez Govan. As much as the defense tried to deflect and get you to choose different deflections, it all points back to Hernandez Govan. Hernandez Govan had choices. He chose to bring Cornelius and Justin together. He chose to encourage them to have a hunt, to go on a hunt. PRE members, but the biggest bounty was Dolph. He knew that Cornelius had a drug habit and that he needed money. And he played upon that. He preyed upon that. And he put him together with someone who was just as hungry for him. Justin and Cornelius were put together by Hernandez Govan. He chose to ask each of them for a cut of the proceeds. He chose conspiracy. Hernandez Govan chose murder. Adolph Thornton will never get to experience many of the things we take for granted in getting old. He will never get to experience gray hair. He will never get to experience wrinkled skin, crackling knees. He didn't get to choose to grow old. That was taken from him and put in motion by Hernandez Govan. You, the jury, you have a choice. The choice is now yours. You have a choice in whether you hold Hernandez Govan accountable for his role in this murder, for his role in this conspiracy. And I ask that you choose to find Hernandez Govan guilty of murder in the first degree and guilty of conspiracy. Thank you.
All right, ladies and gentlemen, I'm picking up on page 27. Deliberation, order of consideration. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. Verdict. Count 1. The charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder, solicitation to wit, conspiracy to commit first-degree murder, and accessory after the fact to wit, first-degree murder. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, solicitation to wit, first-degree murder, solicitation to wit, second-degree murder, aggravated assault, facilitation to wit, aggravated assault, accessory after the fact to wit, first-degree murder, assault. Count 1. When you retire to consider your verdicts, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder, as charged in count 1 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of conspiracy to commit first-degree murder, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder, as embraced and included in count 1 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least. If you find the defendant is guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, placing that offense in that blank, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 1 of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, find the defendant not guilty as to count 1. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. Count 2. You will next inquire whether the defendant is guilty of first-degree murder as charged in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of second-degree murder as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of second-degree murder, including and embraced in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least. If you find the defendant is guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, placing that offense in that blank, embraced and included in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 2 of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, find the defendant not guilty of count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over the deliberations. When you have reached a verdict on a particular count, the foreperson will check the corresponding box on the verdict form and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. Now, there is a couple things you need to know. Pages 33, 34, and 35 are your verdict forms. So I kept referring to check the corresponding box. These are the corresponding boxes. You got count 1 and 2 pages for count 2. Okay. I also have here the official copy of the jury charge. There are a couple of minor changes that I've made, like I caught one misspelled word, a couple of misspelled words. And I've made those changes on here, nothing that's going to change it substantively. But the official copy is going to go back to the back. Please do not write on it. You can write on your own copy. Just use this as the official copy if there's any discrepancy on what you may have with you. Okay, so this is the official copy. So is everybody in a good position to deliver? No issues with the court of law. All right. We shall choose 4 alternates. Once again, all of the exhibits are going back to the back with you. You will be provided a computer, a blank computer that you can use to look at any of those zip drives if you like. Miss Stacy, do you have anything back in the back you need to collect? You'll just stay right where you are, please. Miss Wilkes, ma'am, do you have anything back in the back? Mr. Cobb, do you have anything back in the back?
Just a book.
You want to go get it now? Mr. Ayers, do you have anything back in the back? All right. You want to go collect? If you have any questions, please write them down. Turn on the light. Officer Parks will come collect the questions. George, you are excused to deliberate. Alternate statement. All right. You can stay in recess.
Sounded very crazy.
Always just so lawyers this. I had a bad experience one time, so I always show lawyers what the numbers are, make sure we are clear with them. All right.
talks, Mickey talks, Mickey talks the truth. I got truth on my mind, truth on my mind. I got truth on my mind, truth on my mind. I got truth on my mind, truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
Mickey talks. Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot. My slot